Good morning. Good morning to my colleagues. Thank you for joining us and coming to the meeting in spite of the rain on time. And good morning to all of you in the audience and to those who may be watching us virtually. The Rehabilitation and Social Services Committee will come to order. I'm going to ask the clerk to open the roll.
Madam Chair, you have a quorum.
Thank you so much. We do have a heavy docket today, but we are going to take the cannabis bills first. Because we had a subcommittee that heard these bills and had extensive public comment, I'm going to limit our public comment. It'll be very brief, and depending on how many speakers are signed up, I will determine the time limit. Anybody who has presented a testimony or comment to the subcommittee will not be speaking to the full committee. So I just wanted to set that rule right out there so everybody knows. My first order of business is actually housekeeping. At the request of the patron, I ask that Senate Bill 135 be carried over to 2023. Is there a second? Okay. Will the clerk please open the roll?
Ayes 11, no 0.
Very good. Okay. The first bill we're going to hear, and I know Senator McPike is not here, but other members of the subcommittee are here. So the first bill we're going to hear actually is Senator Hanger's bill. And that is Senate Bill 591. Before Senator Hanger presents, I would like a recommendation from the subcommittee. He's not here, but Senator Boysko, you were on the subcommittee. Do you remember the recommendation of that subcommittee to the full?
The Hanger one?
The Hanger one. It's Senate Bill 591. Let's hear the recommendation.
Madam Chair.
I understand. I'm asking for the subcommittee report first.
Madam Chair.
Senator Boysko.
I can give you the report. The subcommittee reported with a substitute to refer to Judiciary 5-2.
Okay, so you have
so
the substitute.
I so move.
Okay. Senator Hanger, if we adopt the subcommittee substitute, you now have further amendments to that substitute, or should we start from scratch?
Madam Chair, the substitute that was in front of the committee, subcommittee, has been changed significantly.
Okay.
There were issues, and the recommendation, of course, there were a couple of our attorneys, including Senator Serval on there, who wanted to take a look at this no matter what we did here in the Criminal Justice Committee, I believe, subcommittee of the Judiciary. And we think we've addressed their concerns, but it may still need to go there. I think Senator Serval would like to take a look at it this afternoon if we favorably report it. So there is a new substitute.
Okay, so we're going to
Is
go
that
with
online,
this new
David?
substitute. Could you explain it to us and then
Yes, I will explain the intent and what it accomplishes briefly, and then I'm going to have to defer to experts because, as Madam Chair, as you would realize, and I messed up Senator McPike's morning the other day when they took this up in subcommittee, because it took on a life of its own when we wanted to expand the bill to cover some other issues. It began as something that I think was universally supported in making sure these products that are being floated out there that have a broad appeal to children were not able to be promoted and marketed. There's gummies, sugar-coated things that were getting in the hands of children, those types of products. There was another issue that came up. Actually, it came up in our landing team discussions in agriculture and forestry, which I was a part of, because I've been a big advocate for restoring hemp. Hemp used to be a major product in the Commonwealth and nationally with lots of legitimate uses, even building cars, bedding, all kinds of things, where we're hoping this particular crop will find a lot of uses. But the issue that arises, of course, is that there is a method using some of the extracts and then synthesizing it so that it becomes something that is pretty potent and shouldn't be in the hands not only of children, but of young people and older people as well. So the bill has been expanded so that it redefines the higher potency hemps, and it became a 59-page bill with enactment clauses, and it's been shared, this substitute has been shared broadly with many of the stakeholders addressing their concerns. And so I think it's at a point right now where that will accomplish our objective of limiting the ability for these products to be dispersed broadly through convenience stores, little shops adjacent to tattoo shops and all places where people get a hold of these products, which can be in all kinds of forms. They may be sold as cookies, they may be sold as cereal, gummies, all kinds of things. So with that, the technical aspects of it are significant. I met at length yesterday with people from DSS, the forensic labs, and different stakeholders, and David has the detail, so I would defer to him so I don't misrepresent anything.
David, before we adopt the substitute, could you please highlight the amendments that are now in front of us and the nature of a substitute?
Madam Chair. Okay, so the initial substitute that was presented before the subcommittee basically clarified through amendments to the definitions of marijuana and tetrahydrocannabinol, or THC, throughout the code, that any substance that's offered for retail sale that has more than 0.3% THC is going to be considered marijuana, for which you have to have a license to sell, and you can only sell it in retail stores.
Okay.
That's going to be regardless of the type of tetrahydrocannabinol that's present. So Delta 8 has been mentioned a lot. It would not be limited to Delta 8. We also retain the initial shape prohibitions on marijuana products that were included in the original bill.
Good.
And then since subcommittee, we've made kind of 5 more key changes. The first is in 19.2-188.1. We had initially stricken some language about field tests that were approved by DFS. Because they hadn't approved any tests, we went ahead and put that back in to cover situations in the future if they do have an approved test later.
Good.
The next set of changes would be in 4.1-600, 18.2-247, and 54.1-3401, which are all definitional pieces. And then there, we simplified the definition of tetrahydrocannabinol and modified it to cover current and future tetrahydrocannabinols. By basically defining THC as any naturally occurring or synthetic tetrahydrocannabinol, including its salts, isomers, and salts of isomers. Worked with DFS to come up with this language, and they felt comfortable that this was going to cover the current tetrahydrocannabinols and ones that could come out in the future, except for derivatives that would be scheduled by the Board of Pharmacy. The third change was in the second enactment at the request of Senator Servo. I cleaned up the trigger date for the effective date of certain provisions by requiring that the Cannabis Control Authority give notice to the Division of Legislative Services when licensing becomes available, which would then initiate the effectiveness of 3 of the provisions of the bill related to pharmaceutical processors. The fourth category of changes is just some technical amendments that were offered by DFS. And then number 5 would be the third enactment, which is at the very end of the bill, which clarifies that subtitle 2 of Title 4.1, the licensing requirements for selling retail marijuana and retail marijuana products will not apply to hemp extract that's basically processed by a industrial hemp processor who is registered with VDAX, provided those products are below 0.3 THC at the time they're offered for retail sale. Sometimes the THC level of those products gets a little higher at various stages during the processing. They have machinery to lower the THC, so we didn't want to penalize them. Really, it was we were just targeting the THC level at the time they're offered for sale. So we put in this enactment, which borrows language from the larger bill that Senator Evans carrying, Senate Bill 391, So this isn't any new language, but since we don't have those provisions in this bill, we put it into an enactment, but provided 391 passes as well, the language would also be in there.
Well, I seem to like those amendments very, very much. Yes. Go ahead, Senator DeStefano.
Madam Chair, for David May, if I may. So I know, I've read the original bill. I've read the substitute that's 39 pages, but what you're talking about now, I don't see that online. Is that not online yet? Or am I missing something? Because I've hit refresh, like, okay, never mind, it just popped up. So I don't know, this is what? Actually, it's, yeah, all right, so it's up now. I'm going to need some time to go through this.
Well,
Now, we've gone from a one-page bill to a 39-page bill to a 59-page bill, and we just uploaded it. So I don't know what the committee wants to do, but I know what I'm going to do, and I've not had a chance to read the additional 20-something pages with all the changes of the 59-page bill. So,
Madam Chair,
this is the beginning of the process.
I would only
Senator
say
Hanger.
that while it expanded to 59 pages, there are very few pages that have changes on them. As we typically do, you have to expand a long way through the code section to pick up an additional place that you need to make a reference.
Yes, Mr. May.
Madam Chair, I can tell you why the pages increased. So one reason is one of the DFS requested amendments was to add a new section to the code, which was 9.1-1101, regarding the proper methods for detecting the concentration of tetrahydrocannabinol in substances. This is a provision from Senate Bill 391. We moved it in. They thought it should be here just in case, so this could be run as its own independent vehicle and have the provisions that it needed. And then the real reason that it added so many pages is because of the last section in the bill, section
Is that before the-
54.1-3446, which is your scheduled substances. So that's a very large section.
Yes.
And we removed THC from the scheduled substances so that they wouldn't be prosecuted as possession of a controlled substance. So that added a significant amount of pages. to
And
the
that
bill.
that was actually the listing of controlled substances that went on for several pages.
That's correct, Madam Chair.
Yeah, I can see that.
Madam Chair, I would only say also, Senator Serval, Senator McDougal were part of the discussions as lawyers, and if it can be favorably approved here, they want to run it through the criminal law subdivision of the Judiciary Committee.
We will-
So there will be
we will-
additional eyes on it.
I'm
Yeah.
amenable to re-referring it to judiciary, and judiciary can put it into a.
I would also
subcommittee.
say it's compatible with Senator Evans' work this year. Of course, he's the expert on this, has been taking the lead. And as the last time I talked to him, he was supportive of this as well.
Before we go any further, I would like a motion to adopt the substitute as presented before us.
second,
Okay, motion has been made and seconded. All those in favor of adopting the substitute Senator Hanger just explained, please signify by saying aye. Aye. Okay, I will now take public testimony, but I will, are there questions from the committee first? Senator McPike.
So, Madam Chair, just, I guess, a statement. Senator Hanger is dealing with, I think, an important safety aspect that while there were significant changes, he's doing, I think, a good effort to try to capture a holistic view of things that need to be captured in the code. And, yeah, for our subcommittee, we started with a 3-page bill, turned into a 39-page bill. And I think the work that needs to be done, and I would recommend more of the testimony, if they're interested in this subject, be handed off to the judiciary's criminal sub. I'm sorry, which, yeah, you're going to go to crim sub, right? So judiciary's crim sub, to make sure that we get it right on the aspect.
Sure.
From a policy perspective, our sub reviewed it, found there's important aspects that were not covered appropriately. And therefore, I would, out of respect for folks, I would say that for this bill, the appropriate comment period might be, Madam Chair, is for that subcommittee due to the nature and subject matter.
I understand. I will take a few comments, though, before this committee, again,
Doesn't have to go to
with,
finance.
with the hopes that our members will understand the detail.
Let me check.
And I do respect the different scopes within our committees.
Madam Chair,
Senator Boysko.
thank you. I'm hoping that we might hear from somebody who is a real expert in some of this chemistry and THC.
I am going to ask for 5 minutes only. That will be, in totality,
testers,
a
perhaps?
5-minute presentation from people who would be in favor of the bill and could add some expertise to this conversation. I will also take 5 minutes in totality from those in opposition, again, from individuals who have experience or are experts in the area and can add to this conversation.
For those attendees in the Zoom room who would like to speak in favor of the bill, please raise your hand electronically now.
Madam Chair, this is the expert who can answer the questions that Senator Boysko was
Okay,
talking
would
about.
you introduce yourself so we know who
Yes,
we can call
ma'am.
on?
My name is Linda Jackson. I'm the director of the Department of Forensic Science. My scientific background was in drug chemistry. And so we did work yesterday with the senator on making some of the language in his original substitute to be more in line with language that we thought would be appropriate for the testing that we perform and the way that the definitions are used.
Okay, we're going to have you be available for questions.
Yes.
I expect we might get some more. Okay, we've got about 4 minutes left on the pro side.
Morning, Madam Chair. Tom Atorcio with the Virginia Catholic Conference. Had a chance to briefly testify on this bill in subcommittee.
You did speak to the subcommittee, so.
Just briefly, but I just would add that that this is very important work, and I think I'd like to commend the committee on recognizing that. There are over 250 documented cases of toddlers being poisoned by edibles. And so this is a real public safety concern. It unnecessarily taxes our EMTs and our frontline medical staff. And so thank you for considering it. And we'll take this up again in sub at Judiciary. Thank you.
Again, I'm asking for expert comment for those who might be able to further illuminate the technicalities of this bill.
Good morning, Madam Chair, members of the committee.
morning.
J.M. Padini on behalf of the National Organization for the Reform of Marijuana Laws. I would make the suggestion, as I discussed previously with Mr. May, that applying a percentage across a broad spectrum of media is not necessarily the best way to control for THC content. So, for example, there's a product on the shelf right now at Elwood Thompson that claims to have 0.3% THC per each very, I guess, heavy gummy. And that in their math equates to 8 milligrams of THC per gummy. This is a product that's sold without age verification, without any quality control. It is just another one of those products that's on the
So
shelf.
that's something we just have to consider. But the beauty of this is, it is very easy to apply.
It's very easy to circumnavigate the intent of the law. If the intent is to prohibit a product from being on the shelf that has a high content of THC,
Yes.
percentage is not the best approach.
Madam Chair, could I just ask a clarifying question?
Senator Boysko?
Thank you. So, JM, would you say that we would be able to choose how large we're going to call it a gummy for right now, but so if I wanted to claim that I had only 3%, then I could do filler, but still have a very potent small nugget of it. Is that what you're saying is the challenge?
Sure.
Yeah, all right.
Okay. And do you have a suggestion for what would be a better way
In the
of
cannabis industry,
regulating this?
we would not use that type of measurement. We would do milligrams per serving or per total package, that's what happens in the medical cannabis program here in
I
Virginia
guess
currently.
the question would be is how easy would it be to apply something that had a variation of content? You know, so many milligrams for a gummy bear, so many milligrams for,
That's currently the
cigarette.
industry
That-
standard in
that
cannabis would be
that would be-
milligrams. Mhm.
okay, that would be the issue.
Madam Chair,
One
Just-
more question?
just
Senator
follow
Boyce?
up. So in other states where this has been regulated, it's per dose or per piece?
In cannabis products throughout the United States, milligrams per dose and per total package would be the industry standard in an edible type product.
So-
While the percentage might apply, and in this case would apply to a plant product, doesn't translate the same.
So someone who might not, Madam Chair, just follow up. So somebody who might be a novice, who gets a candy bar or some other dosage and it's not clear, and they eat 3 pieces, could end up in a pretty bad situation if they were not aware of how much they were taking. Is that?
Sure, you can go
what
to
we're
Elwood
concerned about?
Thompson right now and buy a product that would be very intoxicating.
Thank
I
you.
am going to ask David May to respond to comment on this conversation.
Madam Chair, ultimately, I mean, I think we'll need a response from DFS, but I think this is probably an issue we could solve fairly easily by, for instance, retaining our 0.3% requirement, but adding additional language to say, but, you know, paraphrasing, but 0.3%, but in no event shall it exceed, for instance, 0.25 milligrams per serving and 1 milligram per package. So then you can't have the instance that she was talking about, that you could just make a really heavy gummy.
Could you add that language now? We don't have that wiggle room in your current language.
Madam Chair, I think we could. I would just defer to the experts regarding those percentages to make sure that that aligns with, we had discussed it after the last meeting, to just hear whether the 0.25 milligrams per serving, 1 milligram per package would be a good place to start.
I guess I would ask the committee if you would favorably consider conceptually.
Well, Madam Chair,
adding
can we have
such
an
language?
expert
I will.
standing in front of us? Can
Yes.
we hear from the expert?
Yes, I was just going to ask that, but thank you, Senator Mason. Welcome.
Yes, ma'am. I believe I would actually want to do the math and check on the actual numbers, but that seems like a good way to move forward because Ms. Bedini is correct that if you have a brownie, it has such a bulk weight that you're never probably going to get something that actually meets that criteria of 0.03% THC. And so she has a valid point, and we can do the math, though, to make
would
sure
think
that
so.
of the right numbers.
Senator Hanger, would you agree that I think we've learned something and we might be able
Yes,
to
I mean,
improve this?
the suggestion she had just tightens it up so it can't be abused. So I certainly favor that.
Okay, so I'm going to ask the committee if conceptually you would agree to such language to be
So moved.
worked out. Okay, there's a motion and a second. All those in favor of that specific amendment in concept signify by saying aye. Aye. Okay, I'm only going to take 5 minutes for anybody in opposition to Senator Hanger's bill.
For those attendees in the Zoom room who would like to speak in opposition to the bill, please raise your hand electronically now. Madam Chair, there are no hands raised online.
Go ahead.
Madam Chair, I'll be brief. Dylan Bishop on behalf of the Cannabis Business Association of Virginia. We are wholeheartedly in support of the initial concept of prohibiting substances that could be appealing to children, but taking a 3-page bill to now a 59-page bill. We just have concerns about the unintended consequences here and just trying to bite off more than we can chew on this piece of legislation. Thank you.
Well, unfortunately, we're going to have to keep things moving. Good morning.
Good morning, Madam Chair, members of the committee. Kyle Shreve on behalf of the Virginia Agribusiness Council, and I've been asked by Martha Moore, Farm Bureau, to register there. We are not opposed to this bill. We are absolutely neutral, but something to consider as you consider both this bill and Senator Evans' bill. There's a very distinct distinction we've made in the code over the past 3 years as we have set up our industrial hemp program between growing the product and processing it. And we've worked with council as well as the Virginia Department of Agriculture and Consumer Services As you mess with these definitions as goes forward, we have worked very hard over the last 3 years to get a state-approved plan at the United States Department of Agriculture because there is a federal definition with that percentage included in it as what is a legal hemp product. The United States Department of Agriculture approved that state plan submitted by VDAX on December 14th of 2021. So as we go forward, the industry is very concerned that we are going to mess with a definition of industrial hemp in the code that would cause us to lose that program. And that means no crop insurance for our producers that are growing currently in the Commonwealth that have been able to do so for the last 3 years, and they are not able to sell it over state lines to another processor. And we are very concerned that that makes the product unable to grow. It becomes too risky of a product for our producers. And so, again, we're not opposed to either bill now, but we have been continually checking with VDAX to make sure whatever comes out of these committees, we want to make sure that those are two separate and distinct products when it comes to being able to grow it so that VDAX can continue to administer our state plan.
Madam Chair,
I appreciate that caution.
I was just going to, Mr.
Senator
May,
Reeves.
are we good?
Madam Chair, Senator Reeves, it's my understanding that we are, and I've done all of these amendments in coordination with VDAX, who runs this program, and they are on the line right now. If the committee wants to hear from them, Aaron Williams is on the line, ready to confirm.
If you've confirmed it, I think we would be fine.
I incorporated all of the VDAX suggestions in this language, so
Okay.
they've thoroughly vetted the most recent substitute.
Okay, well, you are
I've,
very trustworthy.
I've appreciated both patrons being willing to do that for us as we continue to move forward. I just know how these committee goes, and I know it's going to have further along in the process, Senator Servo. We want to make sure that that coordination continues to happen with VDAX so we don't lose that
Madam Chair.
program.
Okay,
Madam
pretty
Chair.
soon I'll be asking for a motion. Senator Servo.
So I just wanted to note a couple things. I mean, all this stuff highlights the difficulties this creates in how this is going to be prosecuted in the future, because one of the best ways to defend a drug possession case is to say that you didn't possess a drug. And, we just redefined marijuana in a over 100-page bill, I think, about 2 years ago because of difficulties classifying Delta-9 versus something else. And but this highlights how complicated this is. And I just also want to say that Mr. May tells me this bill does not have to go to finance. So
No, judiciary. He said it didn't have to go to judiciary. It will have to go to finance.
No, it doesn't have to go to finance, and so therefore, it doesn't have to be done by judiciary on Monday. And so I'm going to be talking to some people about taking this up perhaps sometime next week instead of this afternoon, because I think this is going to take some time to get through. If we're going to take the type of testimony we need to take in order to vet it properly.
My note, I understand, my note does say it has to go to finance. Did they change it? Okay, all right.
So anyway, I just wanted the public to hear that. I'm going to figure it out this afternoon. I'll make some announcement on the floor about what we're doing, because there's a lot of people paying attention to this.
Thank you, Madam Chair.
Well, Madam Chair,
Okay.
due to the legal complexities of the matter, I ask that we refer Senate Bill 591, report and refer to the Judiciary Committee.
As
As amended.
Let me just ask Senator Hanger if he has any further comments. Did you want
No,
to?
I think, I appreciate the time of the committee and all the stakeholders. In fact, the one individual who still had some concerns that spoke here, I would say, there's a possibility he's representing someone who's selling products that we do want to limit, but there are options to still market those products if we do this legislation. One, it can be a scheduled product that can be sold, and also it can be sold through licensed retailers when that is in place. But not through, the little shops that are popping up all over the place along the street there. Thank you. Thank you, Madam President.
Okay, Senator DeStefs?
I just had one quick comment for Senator Hanger. And Senator Hanger, I liked your original bill. I thought it was simple, to the point, and easy to understand. I read the second bill, the 37-page bill, 38-page bill. I read that last night. I had to read it like 3 times. And then if you click on a lot of the links to better understand where it was going, you end up reading about 1,000 pages. I have not had a chance to dissect this bill.
Right, understand.
The one between, I had a lot of questions. Actually, I have a pad of paper almost full with all my questions and concerns. But then when we get hit with another one today, and I'm just saying, if anyone thinks that you understand this, start clicking all of the links start reading the federal code, start reading the other ones, and now I understand why there's confusion, and where we were doing the milligrams per serving, milligrams per package, I understood as I started going through the federal code, I understood the complexity of that as opposed to the percentage, and I understand the debate that happened there. But now I just haven't had a chance to go through this, and I think this requires a little more time than, 20 minutes in a meeting.
Well,
So-
let me just be clear for the public. We did have at least a 4-hour meeting in subcommittee where testimony was taken both from experts and from those in the public who have an interest in this topic. We have read multiple versions. This committee has been briefed along the way, especially during our special session. So this is not the first time we are being introduced to this topic or the nuances in this topic. But as we delve into the detail, I admit, Senator DeSteph, we do learn more and more. So we're going to have to continue, in my view, to keep the process moving and ensure that the respective subsequent committees do their due diligence when they hear the bill.
Madam Chairman,
Yes, Senator McDougal.
apologize for being late. I had another meeting, but I just want to bring up one of the things that we did in this bill was eliminate tetracannabinoids from the Schedule 1. As we go through courts committee, I will be making a motion to return two particular hallucinogenics back to Schedule 1 because I think that that is a pretty big deal and they're very specific in their chemical makeup. But I want to make sure that we're not losing the fact that there are some very hallucinogenic derivatives that can cause real harm and they still need to be Schedule 1 drugs.
Right. And I would agree with that.
I will just, before we take a vote, Senator Eben, you had been standing up trying to speak. I want to give you an opportunity.
I don't want to interfere with Senator Hanger's bill. I was just going to say on both bills, since I have some similar provisions, if necessary, Mr. may want to put an enactment clause that says that certain parts become effective with USDA approval of our, if necessary, based on what Mr. Shreve said, of our definitions. If that's necessary, I don't know if it is.
Mr. May, do you find that suggestion helpful?
Madam Chair, I would suggest leaving it as it is for right now, and if that is a favorable amendment in the minds of VDAX, then maybe we proceed with it, but I think we should consult with them before we.
Yeah.
Okay, a motion is before us to adopt the substitute and the amendment that the committee made in concept. It's been seconded. I'm going to ask the clerk to open the roll. The motion is also to re-refer to judiciary.
Ayes 12, no 0, 3 abstentions.
Thank you, Senator Hanger.
Thank you, Madam
did a good
Chair.
job. Thank you. Okay, now, I know next on the agenda, I was going to take Senator Donovan's bill, but she is not here. So why don't we move to Senator Eben's bill, and I would like to do the smaller bill, Senator Eben, which is Senate Bill 313.
Yes, thank you, Madam Chair. This is what we call a transitional sales bill. As you may remember, in last year's bill that had a number of reenactments, it envisioned a cannabis market, regulated adult use cannabis market beginning on January 1st, 2024. But there's a concern that we've legalized the product, but there's not a legal way to purchase it, a tested product that we know is not laced with things like fentanyl or ecstasy, unsafe products in the black market. And that we've got a pretty big illicit cannabis market. It's valued at over $1.8 billion in 2020 alone. So what we're proposing is rather than wait till 2024, we have medical cannabis in Virginia. Those people who are manufacturing it, to let them sell starting January 1st, 2023. They would be required to sell the product in child-resistant packaging, require that any entity participating in early sales provide quarterly reports on the sales to the CCA, the Cannabis Control Authority, And very importantly, we don't want to disrupt their ability to serve pharmaceutical patients, so the bill would require that they dedicate sufficient number of registers at each facility to registered patient sales and maintain sufficient inventory of cannabis products to satisfy the demands of their patients. So if for some reason they only grew a limited amount and they couldn't meet demand, they would have to serve their pharmaceutical patients first, and that's really important. They've invested a lot of money in medical cannabis in Virginia, and we don't want them to be disadvantaged when retail sales starts. So this allows them to help us with the retail sales. They've got the expertise, allows it earlier. It does require that they educate consumers about responsible consumption, that they incubate up to 5 independent cannabis retailers for a period of 6 months or support and educate persons that wish to participate in the cannabis market. So when the full industry comes online, that there be people with that experience level. It requires a DEI plan, and that they, it limits the canopy of cannabis that they could grow to 80,000 square feet. It adds the local 3% tax that was approved in last year's bill. So basically, it's letting the pharmaceutical people start early with co-located locations.
I'm going to ask Senator McPike for any additional information that the subcommittee may have learned. But I do have a note that Senator Donovan's bill was a request of the subcommittee was to be incorporated.
Well, she's not sure that she wants that. I asked her.
She said no. Yes, she would prefer to have hers as a standalone.
Yeah.
Senator McPike.
Madam Chair, we have a substitute, I think, before the committee that would address a number of elements that the subcommittee also discussed and took up during the consideration of Senate Bill 313, and would so move the adoption of the substitute. And I'll speak to that.
Second. All those in favor of adopting the substitute signify by saying aye.
Aye. Thank you, Madam Chair. So some principal points of discussion in this transition bill that Senator Eben has presented before the committee. There are a number of different factors which were a part of the considerations, one of which is there's a change to the vertical integration fee from $1 million to $6 million. Additionally, the committee worked to amend to limit the vertical integration of this early transition bill to the medical side only. There was, I think, considerable discussion and consideration based on the standards that already exist today in terms of confidence, in terms of consumer protection, as well as having the ability to essentially apply the same rigorous structure that already exists today through the pharmacy board and the medical side to this initial rollout. And so those are the two substantive changes before you now in this substitute, Madam Chair.
Thank you, Senator McPike, and thank you for that very thorough explanation. And you, Senator Eben, went through that as well when you were making your presentation. So
yes,
we do have the substitute before us. I will ask my colleagues, do you have any questions of the patron or of Senator McPike?
Madam Chair?
Senator Reeves.
The only thing I would say is I still have a lot of heartburn going from 1 to 6. I still don't have a comfortable feeling on that number and how we got to 6 million. I think we're going to exclude a ton of people from the opportunity to even engage in this process. So for that reason, I'm throwing up a no.
And could I?
I do have a question, Senator Eben,
if I could
please
just answer
explain.
for Senator Reeves, keep in mind, these are only for the people who are getting an early market advantage, and they're large companies that have deep resources and stand to profit greatly by having that 1-year early entry into the market.
Senator Morrissey.
Good morning, Senator. Good morning. The bill allows a certain number of pharmaceutical processors and industrial hemp processors to sell under the oversight of this board. How many pharmaceutical processors do you envisage will be selling in Virginia?
We have, is it 5 or 6 health areas? We have 5 health areas with 4 franchises currently awarded. They would each be allowed to have a co-located location at each of their branches, and they're allowed up to a total of 6 branches each. So if the 5th health pharmacy area is awarded, is resolved in court, that could be up to 30 locations, a total of about 7% of the retail licenses.
Follow-up question. 5 health districts.
Yeah.
4 different independent, competitive processors, each having 6 locations.
Up to 6, yeah.
So would that be 5 times 4 times 6? 120.
No, it's, if there's one health district has a lawsuit underway about who's going to get that franchise or whatever it's called, and that would be a total of up to 30, I believe, if my math is correct.
Okay, further question.
Senator
What about
Morrissey?
the hemp processors? Is it under the same?
In the substitute, they do not remain. I can't speak for the subcommittee in total, but originally we had hemp in there. But the reality is that in terms of the standards for human ingestion and quality control, if you're going to flip a switch, you could flip a switch and say to the pharmaceutical, is this safe for human consumption? Has it been tested? Does it have like food quality kitchen and that sort of thing? They've got the vast experience. I did have hemp in there originally. They would have a little bit slower. They wouldn't be quite as ready, but medical is what remains.
May I ask either the
Follow-up
patron?
question.
Senator Morrissey.
Thank you. These independent cannabis retailers, do I understand in the bill that they'll be designated for only rural and urban opportunity zones, or will they likewise be in glorious suburbia?
My intention was that they would be at the location of yeah, I think that is the other bill. They would be wherever they could incubate wherever there is a authorized retailer.
I think that's in Senate Bill 391.
All right, thank you.
I do have a question for the patron or subcommittee chair. How did you move from the 1 million to the 6 million? I guess, is there a
Sure.
comparable, can you give me some background on why
So-
you picked 6 million?
So, Madam Chair, I'll happy to respond to the issue. The issue that's before the committee, and I think it was concerned, it's also been discussed at the Cannabis Oversight Commission, is the fact that if you actually look at the ability for the Commonwealth, based on our equity fund, to fund early social equity applicants, actually early capital, we know is one of the keys because of the federal banking limitations. And so part of, I think Senator Boysko and other members of the subcommittee's deliberations were how to provide the necessary early capital to ensure that those new incubated small businesses actually have the ability to get off the ground and be successful in Virginia. Based on the funding timeline, there would essentially be no early capital without this sort of infused early, if there's an early market entry, this needs capital in order to bring these new small businesses to market. And so in fact, even since that time, there's not been a lot of resistance, even by increasing the fee. The other consideration was, as written, the fee would actually have been charged twice under the original bill. Once $1 million under the initial transition license, and then second again in the permanent license structure. And so what the substitute does is actually have a one-time fee, not 2 times fees. And so it actually cut the number of fees in half, but yes, it did increase. And so there is some trade-offs that were involved. So those are the 2 primary components that were of the consideration.
So that it is a one-time fee?
Yes.
Although it's much higher than the 1 million. And the argument about having money up front so micro businesses can be able to access the market is very legitimate. Okay, I will take.
I have a question.
Oh, sure. Senator Locke.
Why were hemp processors removed?
Well, perhaps Senator Boysko wants to speak to that.
Madam Chair, Senator Locke, I was the person who put that in as well. Hemp processors would have the ability to go in and apply with everybody else after the preliminary opportunity. Again, as you heard Senator Eben talk about that, one, we want to make sure that their standards are up to food quality. Secondly, again, in my interest, I want to make sure that those small independent operators have the opportunity to have a fair chance and wanted to even the playing field.
Is that sufficient answer, Senator Locke? Senator Evans, you have any concluding remarks before I
I
will take
think
limited testimony on
of
your
all the
bill.
cannabis bills I've had over the years, I think this is the most straightforward. People who are already in the pharmaceutical program, starting earlier to help meet market demand, allow a legal product, and most importantly, the people who in Virginia who are purchasing marijuana illicitly would be able to buy a tested product that is not does not have ecstasy or fentanyl or life-threatening substances laced in it, and we would be able to start to cut down on the illicit market.
Okay. I'm going to take, again, 5 minutes of comment pro, 5 minutes of comment against. I would like to hear from experts. If the general public spoke to the subcommittee has incorporated your insights into their recommendation, and we thank you, but we will not be taking comments from non-experts today. Anybody wishing to speak in favor of Senator Evans' bill who happens to be in the industry or has some expertise to share?
If there are any attendees in the room who are experts and would like to speak in favor of the bill, please raise your hand electronically now. Madam Chair, I do believe there's 2 people online.
Okay. Why don't you please cut off the sign up for this bill online? Welcome.
Good morning, Madam Chair, members of the committee. Hunter Jamerson, representing Jushi, which is the pharmaceutical processor operating in Health Service Area 2, the Northern Virginia Health Service Area. I'm very grateful to Senator Eben for bringing this bill. It's a complicated concept, advancing retail sales, but we believe strongly in the concept for the public safety rationales that Senator Eben has explained. I will note, and we'll speak to this in Senator Donovan's Senate Bill 621, pharmaceutical processors prefer a July 1 start date, primarily because of the public safety rationale for conducting transitional sales. We do have an immediate public safety problem in the absence of legal sales, but legal possession. We think that is best solved by having a regulated product in the marketplace as quickly as possible. And while Senator Eben proposes to do that on January 1 through the Cannabis Control Authority, we do think it's worth examining July 1 through the Board of Pharmacy as an initial regulator to advance this concept. But we believe strongly in the public safety rationale, and again, appreciate Senator Eben bringing this bill. Thank you.
Thank you. Okay.
Good morning, Madam Chair, members of the committee. J.M. Padini on behalf of the National Organization for the Reform of Marijuana Laws. I would echo the remarks of Mr. Jamerson. This is very much a public safety and consumer safety issue.
It is.
Virginia has the 4th largest illicit cannabis market in the nation. It is entirely a standard policy when a state expands from medical to adult use to enact sales to the already existing operators that have gone through some sort of competitive licensing process. It is the quickest way to onboard consumers to a regulated space and away from illicit transactions.
I think that's important. Next speaker.
Good morning, Madam Chairman.
Good morning.
Good morning, committee members. My name is Caroline Jern. I'm the Executive Director of the Virginia Board of Pharmacy. The administration does have an official position of no position.
Okay, well, thank you. We have 2 minutes left, and we have 2 speakers in the virtual world in favor of this bill. Will the clerk please call the first speaker?
Amber Littlejohn, would you please unmute and begin your testimony?
I am actually not speaking out in favor of the bill. So.
Okay.
Brett Puffenbarger, would you please unmute and begin your testimony?
I am also not speaking out in favor of the bill.
Madam Chair, those are all the hands raised.
Thank you. I will now take testimony no longer than 5 minutes from those who might be in opposition to this bill.
Madam Chair, Dylan Bishop on behalf of the Cannabis Business Association of Virginia. Again, we were wholeheartedly in favor of the bill as introduced, which included the opportunity for 5 industrial hemp processors to participate in this transition period as well. I just want to reiterate that the pharmaceutical processors their product would have to meet the same exact standards as the pharmaceutical processors, and the testing and standards would be exactly identical. And I would just like to remind this committee that The bill as introduced came as a recommendation of the Cannabis Oversight Commission, which studied this topic in depth over the summer. The Cannabis Business Association would just appreciate if you guys would not take the amendment and revert back to the bill as introduced. Thank you.
Thank you. Mr. Peep. Senator Morrissey.
I just want to clarify, I think you may have misspoke. I think you meant to say the hemp manufacturers have to meet the same standards as the pharmaceutical manufacturers.
Yes, sir. Under this bill, the hemp processors and their product would have to meet the same exact high standards as the pharmaceutical processors. Thank you, sir.
Okay.
Madam Chair,
Mr.
members
Dean.
of the committee, thank you for having us. Greg Habib with Gentry Lock here on behalf of a few dozen Virginia farmers and hemp processors. Let me be clear. We have no objection to pharmaceutical permit processors going early. We work with those folks. We think very highly of them. We think the market needs to be filled. Our objection is to removing the hemp processors as was recommended by the Cannabis Oversight Commission and as was in the bill as introduced. These are the Virginia businesses, the Virginia farmers in this market, and what we're doing is preferring out-of-state businesses versus the Virginia businesses. One point of clarification, most of my clients, all of our clients are VDAX regulated. Most of them are food grade certified. Most of them are currently inspected and selling edible products. Clearly, the pharmaceutical permit processors are professional and good at what they do, but I don't want you all to think that the hemp processors are just farmers with no idea how to sell a product. These are Virginia businesses, inspected, graded, selling products. We think we should be able to go as well. That's all. Thank you.
Madam Chair.
Thank you, Senator Morrissey, and then there's only 2 minutes left
If
for
I could
those
just get, thank you,
in favor.
some explanation either from the speaker
Opposed, rather.
or I'll wait until everybody's finished. If I could
I
get
guess the
some
court to stop
explanation from
signing.
either the speaker or Senator Eben as to why we took hemp out. I mean, the hemp manufacturers are the folk in Virginia that have the hands in the dirt in Virginia, that are Virginia citizens, Virginia employers and employees. Why did we take them out of the bill and leave in the pharmaceutical folk who are, for the most part, out of Commonwealth entities that are doing business in Virginia with their pharmaceutical shops? I'm just trying to get my head wrapped around
I want to address
that.
the second part of your question about the out-of-state entities. The people who are employed in Virginia are Virginians. They're employing Virginians. Their activities are in Virginia. They don't cross state lines. I don't know about all their investors or who owns the company, whether they're all out of state or some out of state. But I just want to be clear that they're operating in Virginia. They're now, whether you call them a Virginia subsidiary or a Virginia company, it's all happening in Virginia. It doesn't cross state lines. I did introduce it with hemp. I don't want to speak for Senator Boysko again, but the one distinction I will point out is that the medical cannabis people are doing this right now. But I did introduce it in the other forum. But the people we really need on day one are the pharmaceutical. I recognize you have some interest in the hemp, and I can't speak for Senator Boysko.
Madam Chair.
Yes, Senator McPike, and then I'd like to finish going through our commenters. Go ahead, Senator McPike.
Thank you, Madam Chair. And maybe to point a little bit finer point on it, part of the discussion in the subcommittee was, any of the infrastructure and investment that have been made today have been made solely for the purpose of industrial hemp, which is a very different standard. And so if there's those that are speculating that other extracts for adult consumption on other speculative investment is purely speculative and has not met the same rigorous standard of medical. And so for the purpose of this bill, which is a transition bill, the comfort in terms of the consumer and the safety relied solely on the medical side. And that was part of the subcommittee's decision and consideration. And frankly, ease of, I think, the transition of safety based on existing regs versus relying on wholly different industry applying to this concept. And so, Madam Chair, I just want to make sure that was a more finer point about what the decision was.
Mr. Habib, you already spoke. Do you have something to add?
Well, I was just going to Senator Morrissey's point. Again, we don't object to pharmaceutical permit processors going early, but hemp processors have also spent millions of dollars investing in infrastructure in an industry that is largely going to be wiped out by the new legal cannabis market. And these folks are these folks are inspected, they are graded, they do have food grade products, and we just think they should also be allowed to go early.
Thank you. We understand your point. Okay, 2 more speakers, and then we're actually going to go to anybody else who wants to speak in opposition, which, go ahead.
Philip Thompson, the Cannabis Equity Consultants, and I come with my usual pitch here is that when you selected the medical cannabis people, there was no equity considerations in any of those selections. So you have no minorities involved in that process at all. And we'd like to see something come that accelerates this action for minority people to be involved, because you know who the impact of marijuana has hit for the last 100 years. So we hope that you do something in that area. Thank you.
Thank you. Yes, sir.
Madam Chair, Tom Matorcio representing the Virginia Catholic Conference and Virginians evaluating drug legislation. The notion that that regulation will curb the illicit market has been borne out as false in every state that has commercialized THC. Notably in California, the General Assembly, California approved commercialization in 2016 by voter initiative. 5 years later, the illicit market is outperforming the regulated market to the extent that the California General Assembly had to appropriate $100 million for a bailout of the legal market. So the notion that you can regulate out the illicit market is completely false. Thank you for your time.
Thank you. Okay, as I said earlier, I will take 5 minutes for those in opposition. We've already heard from, we had sort of a mix here of both proponents and opponents. So we've got how many speakers? 1, 2, 3, 4.
Madam Chair, we have 5 speakers.
5 speakers. I'm going to ask each speaker to keep your remarks to 45 seconds. And I will ask the clerk to call the first speaker. Thank you.
Brett Puffenbarger, would you please unmute and begin your testimony?
Yes, hi, my name is Brett Puffenbarger. I'm the managing partner of a cannabis consulting company called Good Ideas, and I am here representing my clients with the Minority Cannabis Business Association today. I just want to point out that by offering early market advantage to large multi-state operators who are not Virginians, despite employing Virginians, and giving them a 6 dispensary cap effectively allows them to corner the market and does the opposite of the intention of the original bill, meaning helping Virginians participate in this newly legal market. I believe that the Minority Cannabis Business Association report on social equity and licensure in this way would be a very relevant piece of information for the committee, the senators, and anyone else interested to consider. It actually shows detrimental impacts when enacting early market advantage for large processors. And I don't think it is a public health concern, because what is proposed in allowing this is actually going to continue to proliferate the black market, because these companies will not be able to meet the demand. They're set up for a very small set of things, and even with an expansion of 30 dispensaries, that's nowhere in comparison to the estimated amount we would need based on the original legislation allowing for hundreds of locations across the state. I think we're setting ourselves up for failure, and we're looking at a fear-mongering approach that does not actually serve the community, the Virginians, or anybody else who is not necessarily one of this small group of multi-million-dollar out-of-state companies.
Thank you so much.
Thank you. And how can I submit the embargoed report for your consideration?
You may submit it to District 31 at senate.virginia, spelled out, .gov, and we will make sure that all members of the committee get your written testimony. Thank you.
Thank you for your time.
Sure. Will the clerk please call the next speaker?
Tom Griffin, please unmute and begin your testimony.
Thank you, Madam Chair. Tom Griffin with Purely Appalachia. Tuning in today to rise in opposition to this bill. Purely Appalachia represents a coalition of farmers, retailers, and an industrial hemp processor in the southwest region of the state. We have been working with the Cannabis Oversight Commission since the latter part of 2021. In the fall, the industry was tasked with determining a solution for this transitional period The determination was made and was reflected in the original form of 313 to provide a framework that would convert on or at, somewhere before January 1, 2023, 5 industrial hemp processors and 5 pharmaceutical processors. Our concern is that what we have here today is only 4 pharmaceutical processors, which we believe will be inadequate to meet the consumer needs within the state and be in a position to support some of the individual retailers moving forward. And so we would request that we reconsider this provision. I would add one piece just quickly.
Very quickly.
In terms of the onboarding process, there's been a discussion about whether or not there would be the same vetting process for industrial hemp permit holders as pharmaceutical processors. Part of the provision in the agreement, the original agreement of 313, was that those 5 industrial hemp processors would, subject to onboarding and licensure, be required to go through the identical steps that were required of the pharmaceutical processors to be licensed. And so we're not advocating for an auto conversion under different standards, but rather to be held through the same standards for licensure.
Thank you so much. The clerk.
Thank you, Senator.
Amber Littlejohn, please unmute and begin your testimony.
Welcome, Amber.
Good morning. My name is Amber Littlejohn. I am with the Minority Cannabis Business Association. I would like to say that what the previous individuals who have given testimony have said is true. This has been done before, and it has never actually prevented the legacy market or the unregulated market. In fact, to the contrary, early market access and overly limited markets have contributed to the proliferation of the illegal market. In fact, currently, a state, California, that allowed early market access to medical operators still has, to the day, almost 80% of sales being conducted in the legacy market. The idea also that it will get safe product into the hands of individuals while creating a robust, unregulated market is also preposterous because, again, the issues with tainted cannabis products are happening in California, Michigan, and Illinois. It wouldn't just be early market access. There would be other advantages, including exemptions to vertical integration, exemptions to opt-outs, and all of the additional advantages that come from both early market access and having a monopoly or oligopoly in a given area.
Amber, I have to ask you to conclude.
Yeah. So again, we ask you to refer to our report that again provides ample evidence that this does not actually address and in fact would harm and definitely prevent small businesses in Virginia from taking part.
Thank you so much.
Evan Smith, please unmute and begin your testimony.
Hi, my name's Evan Smith. I'm a community organizer with Marijuana Justice, also resident here in Richmond. We oppose this legislation and we appreciate the opportunity to comment. Thanks so much.
Thank you so much. And we have one last speaker.
Derek Wall, would you please unmute and begin your testimony? Derek Wall, would you please unmute and begin your testimony? Madam Chair, it looks like he's walked away from his desk.
Okay.
That's all.
All right, colleagues, this bill is before us.
Madam Chair,
Senator McPike.
before making a motion, I did want to appreciate one of the speakers in opposition to bring up one point, which is one of the provisions that the subcommittee did include in the substitute, which was a consideration, is basically the concept of canopy cap. And canopy cap is applied to the licensee to ensure that the cultivation opportunity is not limitless. In other words, we also incorporated building and preserving future market opportunities for small businesses and others by using a canopy cap within the bill. And so there are a number of different provisions that we're looking at to make sure that even if awarded a licensee under the structure, it does not allow for sort of the continued wild west of one licensee to dominate a market. So with the provisions of the limited number of retail license and the limitation of a canopy cap, we felt more comfortable that it still preserved future market opportunity for all those that are looking to enter into the market, Madam Chair. And at the proper time, I'd move the Senate Bill 313 report and re-refer to Finance.
Thank you, Mr. McPike. And of course, we're reporting the substitute, and the motion was to re-refer to Finance. Senator Eben, do you have any concluding remarks?
Just to respond to the speakers, I just want to say California's problems are not the result of medical purveyors being allowed to get in the market, and it's illogical to suggest that providing a tested, safer product does not combat a dangerous illegal market.
Okay. All right, colleagues, a motion has been made and seconded. Will the clerk please open the roll?
Ayes 7, noes 7, 1 abstention.
Do you want to reconsider?
Well, I asked to speak, Madam Chair, and you didn't call me.
I apologize.
That's
I did
okay.
not see you, Senator Morrissey.
Fine. Well, let me tell you what I'm worried about.
Okay.
There used to be a legislator named Henry Howe, and he talked about keeping the big boys honest. Here's the problem I have here. I didn't know anything about hemp until 2 years ago when I chaired a small minor committee that met in a closet. But I learned a little bit about it. And what I learned about it is that we have hemp manufacturers in Virginia. Men and women that have their hands in the soil. They are manufacturing hemp. And in this bill, and I appreciate all the work that you did, Senator, and I also appreciate Senator McPike's explanation. But we took the hemp manufacturers out because we said the big boys know what they're doing, the pharmaceutical folk. Those folk, most of whom have out-of-state corporations that have set up 4 locations in Virginia, they know what to do. So let's just do this. Let's let the pharmaceutical folk that are already there continue, take the hemp people out, and we'll have a sunset on it. And we'll let the hemp people back in when we're ready. The problem with sunsets is that, unlike over the James River where it happens every day with certitude, sunsets in the Virginia General Assembly tend to be extended. That's the problem that I have with this bill. I haven't heard an explanation why we took Virginia homegrown hemp manufacturers out. That's why I voted no. And unless somebody explains that to me, it's going to remain red.
Senator Eben, you may respond. I'd also like to hear from
Well,
Mr.
I didn't
May.
actually take them out, but I understood why the committee did it, but I don't want to speak for the subcommittee.
Madam Chairman, I have a point of order. Where are we procedurally? I mean, we have a bill that's been,
We have no bill before us right now.
okay, so we're
This is a conversation.
okay, we're still in the bill because it did not report, so,
It did not report, so we have no bill before us.
Okay.
We're having a conversation, and we'll maybe ask for reconsideration of the last vote. So this is a conversation right now.
Madam Chair, I'd be happy to take up
Senator.
Senator Morrissey's questions in the deliberation. This was an important part of the considerations. The first part is, number one, industrial hemp is an important part of the viable commercial future market, number one. And the investments made today are very important. We anticipate that actually that will continue. The market expansion of industrial hemp as a product is continuing to expand as a product in a commercial market. So the investments that are out there today will continue to be viable. Number two, the consideration is the actual regulatory standards and the rest of it is very different. Number three, the market opportunity still is provided and available to any of those who wish to step up and provide those future market opportunities through the limitation of the canopy cap that I addressed just before the motion. And so there are a number of different provisions that, number one, never excludes anyone in the future opportunity. Number two, we already provide sort of the safety parameters and regulation in terms of ensuring that no one individual company dominates the market, which is important. The other part that we have been working through is also product diversity on shelves. And so that's one of the concepts that we're going to be working through to make sure that any one supplier doesn't necessarily have 100% of, say, Joe Morrissey, whatever product on one shelf. And so there's a number of different methodologies that we're trying to incorporate to ensure the successful future market for all new market entrants. Madam Chair.
Morrissey.
One question to Senator McPike. Do you envision a situation where the hemp manufacturers who, as already been testified to, have a significant investment in Virginia, will still be a significant player in this market. Is that going to happen?
Yeah, not in the early market of the first year, but after that, they can get a license just like anyone else can.
Madam Chair, and part of the complexities is also the transition of, I think, the regulatory, because the Cannabis Oversight Authority has not yet transitioned and been stood up. And so the question, the policy question is, as you work through the transition, because there's an existing regulatory framework, we wanted to make sure we just transitioned through this transition period through the existing structure in order to stand up and get the VCCA's regs in place for the full market. And so there is some nuance and transition and complexity, but that was the work. And I know, Eben's put in a significant amount of work to get us here.
That's a really good explanation. Okay, colleagues, what is your preference? Senator Boyce?
Madam Chair, having voted on the, no,
you didn't.
I didn't.
I'm going to ask consideration of those who had voted on the.
Well, Joe wants to, Senator Morrissey's.
Senator Morrissey.
Ask that we
Reconsider.
reconsider the vote on which it just previously tied 7-7.
Is there a second? All those in favor of reconsidering the vote that we just took, signify by saying aye. Aye. Oh, it's a recorded vote.
Ayes 15, no 0.
Okay, the bill is now before us. May I have a motion?
Move to report and refer.
To Finance. Okay. Motion has been made by Senator McPike, seconded by Senator Boysko. Will the clerk please open the roll?
Ayes 8, no 7.
Your
Thank
bill
you.
reports and is re-referred to Finance. Thank you, Senator Eben.
Thank you, Madam Chair. Did you want to take up the other one now, or?
I would like to take, is Senator Donovan still here?
Well, the two bills were at a little bit different. I mean, you probably wouldn't have both, and the committee recommended, the subcommittee at least recommended the one that you just
Yeah,
passed.
she does not agree to have hers rolled in. But
Right.
since she is not here and you are here.
Okay.
Let's move to
So
your
this is the big enchilada.
your big enchilada.
This is SB 391. Now, the substitute should be online now, right? It's released.
And colleagues, before you start, Senator Eben, and I will ask for the recommendation from the committee before you make a presentation. Colleagues, please look at your desk, and there should be a side-by-side here. Senate Bill 391 to assist you in going through the major components of the bill. And this was put together by actually Senator Eben's staff with input from David May. Senator McPike, do you want to give us a subcommittee report on Senate Bill 391 before we turn to the patron?
Thank you, Madam Chair. The subcommittee took up and did utilize the spreadsheet that was prepared just because there are a number of different provisions from our legislation last year that helped to transition to where we are. A lot of that was also influenced by the work of both the prior administration at looking at technical fixes in collaboration with Mr. May. Additionally, with input from the Cannabis Oversight Commission, which myself and Senator Evans serve on, to help inform the different technical components of establishing a legal market in Virginia. Through the process, there are a number of different considerations through both the Oversight Commission as well as through this vehicle that have been put in place to try to provide a framework where Virginia can, number one, provide a safe standard across basically two concepts, if you want, Madam Chair. It is essentially that, in concept, we want to ensure that, number one, the industrial hemp, those who are going to provide product in that space, would still remain under VDACs as a pure agricultural product. But number two, more importantly, is any of those products that became adult consumables would fall under the Cannabis Authority's regulations. We felt that was a very important thing that is now reflected in this bill, and sort of make sure that we had very clear lines of regulation, number one. So we did not want to inadvertently put industrial hemp within a strong regulatory environment that we would want under adult use. And so we made sure that that was clear. There are a number of different provisions that are outlined within the bill. Ultimately, with the stand-up and adoption of regs, and I'll let Senator Evans speak to more of the specifics, but he has incorporated a number of, I think, pending questions that we had from last year that with additional information over this prior year has made this bill in a much better posture than the prior year, Madam Chair.
Thank you, Senator McPike. Senator Eben, please present your bill.
Thank you, Madam Chair. So you may remember that one of the enactment clauses in last year's bill said that we were going to have the JLARC review last year's bill and see how it tracked with the original JLARC recommendations on how we would stand up a legal market if we were to do so. So JLARC went through, the Cannabis Oversight Commission reviewed the JLARC recommendations and accepted, I think, nearly all of them, if I'm not mistaken. We had, as Senator McPike said, requests for the Northam administration, and we made some independent assumptions too. But largely on this sheet you see, this should include all the provisions of the bill. So I'm just going to mention a few. The Northam administration realized that we didn't have a defined punishment for not labeling homegrown plants, so we made that a $25 fine because otherwise it would have been a significant fine. We maintain the ability to enforce possession with intent to distribute marijuana past January 1st, 2024. As Senator Hanger's bill does, CCA regulates all products with THC for human ingestion, including Delta 8, 10, et cetera. That was the request of the Northam administration, an important provision. We transfer the the oversight of hemp extracts and smokable hemp products from VDX to the CCA. We changed the Cannabis Public Health Advisory Council by recommending that we add a marijuana testing lab expert and consumer advocate to that council. We allow the CCA to establish license categories like the size of the marijuana, like the size of the license of cultivators. We allow the CCA to set all license caps except for retail. That's a departure from last year's bill. We had capped different types of licenses. We're still capping at 400 retail licenses. But in order to meet demand, or say that you have a lot of small growers instead of big growers, we wanted to give them the flexibility to make that work. We allow businesses, we talked about micro businesses or micro licenses in last year's bill, didn't really define them. So this year, what the Cannabis Subcommittee did the other day was we said that businesses that are under 8,000 square feet of canopy can vertically integrate. That's a small business, but we cap the canopy limit at 80,000 for the vertically integrated pharmaceutical processors to prevent market domination. We allow the governing body of counties, cities, and towns to adopt an ordinance that prohibits public consumption or consuming or possessing marijuana on public school grounds. We say that the licenses are non-transferable to prevent them from being gobbled up and into the hands of one big super company. Hours of operation. This was something I brought to the Cannabis Oversight Commission. In last year's bill, it said localities could limit the hours of operation. I didn't think that was sufficient, so what we're doing is saying you can't sell between the hours of 9 p.m. and 8 a.m. for retail. The subcommittee changed the fee as was discussed. You pay $6 million either for early sales, or if you get in at the late sales, you don't pay $6 million twice under this bill or under the combination of the bills. We updated the open container section to remove for the open container standard to make it clear that if cannabis is accessible to the driver or passenger of a vehicle and in an unsecured or unsealed container, it's a permissive inference that that's an open container. We put a small penalty for importing or transfer cannabis into Virginia, keeping in mind that there's also an intermediate penalty for possessing a certain amount, and if you possess a large amount, you still face a hefty penalty and jail time. I don't know if that was that 5 pounds or a pound? What was that? 1 pound. So if you have more than a pound, you're already facing a hefty penalty. So the penalty for importing is relatively small, so that if you get caught with a gummy going across the Key Bridge or something, that you're not going to incur the major penalty. And then in terms of the expungement and resentencing, there's some provisions in the bill, but what our intention is, Senator Lucas and Senator Surville have bills in courts on that, and my intention is to take the language that courts agrees to and marry it up when it comes to the Finance Committee. And we also, in Enactment Clause 10, require that the Cannabis Control Authority promulgate regulations by January 1st, 2023, rather than July 1st, because if you're going to have a market starting on January 1st, 2024 for the larger market, you need the regulations in place earlier. And I'm prepared to take questions if there are.
Thank you for your very detailed presentation. We really appreciate this table. Senator Boysko.
Madam Chair, one thing that we talked about in the subcommittee was around advertising, which I don't think you addressed. There are members here who have a lot of heartburn about advertising. Senator Kiggins and I.
Yes, that was an important amendment.
Stand united as the Jennifers who.
And I don't think that I added it to this chart, but Mr. May, the amendment that we made at the behest of Senator Kiggins and Senator Boysko, I believe we were saying in concept, and I don't know how you defined it, no TV or radio advertising as long as we were going to do it the same as what was for tobacco and alcohol.
Mm-hmm.
Yeah,
let me ask David May, because I think he was tasked with coming up with some conceptual language. This is a little tricky because we do have the First Amendment, freedom of speech. So go ahead, David.
Madam Chair, Senator Boysko, I did the best that I could. I got with ABC, and ultimately, we don't want to align with, as Senator Surville pointed out last meeting, we don't want to align with the rules on tobacco. That's a federal issue. We have rules about alcohol, so that was more of the route where we could look at what our current structure is. We aligned everything, so we basically compared the advertising rules for cannabis with alcohol. And in any instance in which our rules were more lenient than alcohol, we amped up those rules. So they were more strict in some occasions, but in areas where they weren't, we made adjustments there. So I'm happy to run through the changes that we made at the pleasure of the committee.
Yeah, why don't you just explain the changes? I too am very interested in not promoting the use of cannabis or marijuana. Go ahead, David, if you could briefly describe.
Yes, Madam Chair.
Thank you so much.
So you're going to find all of these changes in sections 4.1-1404 and 4.1-1405 in the bill, in the substitute before you. Like I said, we made the rules as strict as alcohol. So the first section, 1404, is really about all advertisements. The next section, 1405, is about outdoor advertisements specifically. Mm-hmm. So in the first section, 1404, that applies to all advertising, we added some rules that prohibit advertisements that imply the use of cannabis would increase athletic prowess. We also put in a prohibition on advertisements that mention anything about the intoxicating effects of cannabis. We prevented advertisers from implying that you're going to get something of value or condition your entry into a contest on the purchase of cannabis. We prohibited advertisers from depicting anyone consuming cannabis in the ads and also using anyone as a model who was below the age of 21 years of age. And then finally, in that section, we put a prohibition of any implication that a cannabis product was government endorsed. As for the outdoor advertising, a lot of the rules there revolve around, being within 1,000 feet of certain places. There are some other rules as well. But regarding that 1,000-foot limitation, we added on any place of religious worship. So you can't be within 1,000 feet of that, or any dwelling for residential use, or also on property that's zoned exclusively for agriculture or residential use, or on unzoned property. And in doing so, I started to really look at that 1,000-foot language, and it was very difficult to read. I wasn't entirely sure what it even said, so I cleaned that up at the same time to basically just say the 1,000 feet is calculated between the edge of the sign and then the property that you're looking at to find whether it's too close or not.
I believe, if I'm not mistaken, that, Mr. May, that we also have a prohibition on billboards.
Madam Chair, Senator Urban, that's correct.
Yes, so, and then further, I believe in last year's bill, it said that advertising had to be in a medium that was, I'm not sure which it was referring to, 85%, this was the House provision from last year, 85% targeted to people 21 plus. I know Senators Kagan and Boysko wanted outright ban on TV and radio, but I don't know the constitutional implications of that, but the 21 plus means that if they're, like if you're on at 11:30 at night and the ratings book shows that it's 85% 21 plus, then you can be on it, but you couldn't otherwise. So you won't see it on the family, you know, what I would call prime time.
Madam Chair.
That's very helpful. Senator Boysko?
But, Madam Chair, a question for the patron. But, so let's just say I'm on YouTube or my child is on YouTube. Any restrictions or consideration of you know, internet-based ads? Because we all know that.
I'd have to ask Mr. May, I don't know if there's ratings on the internet, or if can we put something in that if something is, if someone has settings on their computer restricted to children, I guess that's up to the people who do the ratings, what they see.
Madam Chair, Senator Boysko, there are some limitations regarding the internet generally, as far as ensuring that someone, you know, going to a site or signing up for emails or anything like that is at least 21 years of age. Beyond that, most of all of our advertising rules in 1404 would apply to internet ads, even though we don't mention them specifically because it applies to all advertisements. I would say, and I spoke with Mark with JLARC, I'm sure he's probably here or around watching, and we looked back at, I got some data from him. They had looked back in 2020 at some of the advertising rules across the nation, and specifically 6 of the 10 states that had legalized recreational marijuana at that time. There was not a single state that had a blanket statutory ban on radio, television, or other mass media advertising. And one of the common themes was this percentage that requires, you know, that a certain percentage of the expected audience be above the age of 21 in order to hear the advertisement. What JLARC found was that percentage was normally set around 30. Ours is much, much higher than that. So if anything in that respect, our rules are more strict than the other rules that JLARC looked at least in that respect.
Okay.
Thank you, Madam
We
Chair.
have heard such extensive testimony on this bill. I am not going to take public comment at this time. This bill will have to be re-referred to Finance. If somebody feels very compelled to send a message to this committee, you may send a written comment to me, and that would be District 31 at senate.virginia.gov. I will make sure that any correspondence I get regarding this bill will be shared with all of my colleagues. Senator Evans, do you have anything further you want to say?
No, thank you for your consideration. Just that these recommendations in the bill largely were, many of them came from the Cannabis Oversight Committee that studied some of these things. A number of them came from the administration, as I said, some from JLARC. But this is still an evolving process. If members of this committee want to see further refinement, please see me, and I'm open to other suggestions as the process continues.
Okay. The bill's before us, colleagues. Okay, a motion has been made to report the bill and re-refer the bill to Finance. Will the clerk please open the roll?
Ayes 8, no 7.
Your bill reports, and it will be
Thank you to members of
Finance.
the committee and to the Republicans on the committee. If there's things that would make you want to vote for it, let us know.
We appreciate your collaborative nature. I hear from David May that you have made every attempt to make as many stakeholders comfortable as possible. Senator Cosgrove.
Thank you. Before the Senator Eben leaves, I'd like to thank him for this chart that he provided. This was very, very helpful.
It was very helpful.
Answering a lot of questions. So thank you for all the work you put into this.
This guy here has done it all.
Well, thank him too, Dan.
Would the clerk please call Senator Donovan? Can she be available? If not, I can go to other bills while we wait for her. You do have one. I know you do. Senator Mason, did you want to present your bill?
Madam Chair. Okay. Thank you, Madam Chair. I have Senate Bill 689.
Colleagues, please turn your attention to Senate Bill 689.
Madam Chair, members of the committee, we discussed Senator Edwards' barrier crimes bill previously and had some fairly robust conversations. I think Senator McDougal was trying to make some very positive tweaks to it. But Senator DeSteff and I had a colloquy during the discussion of how difficult this is. I mean, you can always pull out something that's tough and hard to get accomplished. So what I am trying to accomplish here is kind of the same strategy we did with offshore wind. The offshore wind bill was a part of the Clean Economy Act. That was an enormous undertaking. We separated that out separately. They both ended up passing. Wonderful. That's my hope here. What I have done here is separate out foster care. And foster care, one of the biggest problems we have, particularly with kinship care, which we're promoting aggressively in the state, is a previous long ago conviction that falls on the list. So all we've done here is try to make it simple. Under foster care guidelines, we are using the federal requirements. So federally, if you are prohibited from adopting and being a foster parent based on the crimes committed, you're out in Virginia. But beyond that, we can look to kinship care. Remember, every time we're talking about these barrier crime discussions, it's not an automatic check. You're not approved. You just are a way to get yourself in the process, be evaluated, be analyzed, and to give you the opportunity to hopefully adopt a child and keep them out of foster care. That's a bill, Madam Chair.
I have one question, Senator
Yes, ma'am.
Mason. So the Department of Social Services would issue regulations on the waiver process, so that would go through a stakeholder, the regular regulatory process where stakeholders are involved and it's advertised? That's my question.
Well, so since we're following federal law, I don't know whether, I think since we're following federal law, it would go through our standard promulgated process.
Correct.
That we have today. You would just be able to, you would just have the list of federal exclusions that you could not adopt
Right.
and apply those.
And then the process by which you could apply for a waiver because you were not federally excluded would be public and available.
Yes, ma'am.
Okay, because that's
Yes, ma'am.
really
Yeah,
the
you mean
catch.
beyond, I'm sorry.
Yes,
I'm sorry.
yeah, I meant beyond.
This just gives you the
Okay,
opportunity.
it's a very good bill. It is a subset, actually, of Senator Edwards' bill, but I am very, very much in favor of having this go on its own track. So I thank you for that. Do you have any speakers?
Madam Chairman,
Senator McDougal?
I did have, I'm not familiar with 42 USC
I know.
671A20. Could you go through and tell us what those are? And so, and I guess my question is, what's the difference between the current law and what the federal code is?
So I did pull that, Madam Chair, Senator
Yes, Senator
McDougal.
Mason.
The couple of paragraphs that I found most relevant, and maybe Mr. Megan check me, is you would not be eligible based on crimes against children, including child pornography, crimes including violence, including rape, sexual assault, homicide, but not including other physical assault and battery. If the state's found a court of competent jurisdiction that the felony was committed at any time. Then in any case involving a child, and this is still, by the way, you still full background check requirements. The background check reads a felony conviction for physical assault, battery, or drug-related offenses. And so there are just a couple that are called out in this subsection, which I have here and can give to you if you'd like to review it in depth, Madam
Senator
Chair.
McDougal.
Senator
Madam Chairman, so I guess maybe this is for David. So the things that I'm probably the most concerned about are violent felonies. So all those things, rape, robbery, arson, those types of murder, those types of things, are those going to be barriers currently or not?
The things that I just called are the things in the federal law that you cannot.
Okay.
Is that?
Mr. May, do you have further comments?
Madam Chair, Senator McDougal, violent crimes are prohibited, are a barrier crime underneath the federal statute. The way that the federal statute is worded, which is 42 USC 671 A20, it says a crime, this is just one piece, but a crime involving violence, which is obviously pretty broad. We have different categories, which you're well aware of in Virginia regarding violent crimes, but I think a crime involving violence is broad enough that it would cover all of our violent crimes.
Madam Chairman?
Yes,
So-
Senator
so
Dugal.
Would that include domestic assault and regular assault?
I'll have to look.
Madam
Under a
Chairman,
federal definition.
Madam Chairman,
Who's calling me?
Surville,
Oh, Senator Servell.
thanks. I'm looking at the statute and
Not including physical
the
assault.
statute doesn't, it says a felony conviction for, and then it says, or a felony conviction for child abuse, neglect, or spousal abuse for a crime against children, or for a crime, it doesn't say felony or misdemeanor, involving violence. But not including other physical assault or battery. So that's what it says for section 1. Section 2 says any case involving a child reveals a felony conviction for physical assault and battery or drug-related offense. So,
So, Madam
I'm
Chairman?
not clear if domestic assault is clearly in or out. It's, I'd have to go look at the annotations.
Well, I'm going to call on Senator McDougal, then I'm going to ask David May to respond.
So, Madam Chairman, I think as I'm looking at what Senator Servell was saying, it says, it does specifically say sexual assault or homicide, but then it says, but not including other physical assault or battery. So I would think that malicious wounding, unlawful wounding are you could still, I don't.
Violence.
I would say not including other physical assault.
So you're saying other physical assaults would be permitted, is your point, Senator McDougal?
That's
Based on your
that's what
reading.
this says. And I'm not, again, I'm not federal, I haven't looked at this code
But
at
again,
all.
this, you know, we're talking about a waiver process. So, Mr. May, can you enlighten us?
Madam Chair, yeah, I mean, and looking at it further, I think you read it exactly right. A violent crime is going to be a barrier crime, and we're also going to include anything related to rape, sexual assault, and homicide, but it doesn't include other assault or battery. So if it's not going to fall into the categories of a violent crime or rape, sexual assault, or homicide, then it will not be included as a barrier crime.
Senator Morrissey?
Thank you, Madam Chair. I think we may be wordsmithing this just a little too much. Just look at line 72. It's pretty clear and succinct. The child placing agency shall not approve a foster or adoptive home if any individual has been convicted of, and then insert the words, a crime of violence. All right, because that's what 42 USC is. So they cannot be a foster parent if they have been convicted of a crime of violence. Do we need to go any further than that? We can wordsmith simple assault, a dust up between a couple of brothers all day long. They're not going to get proved if there's been a crime of violence. Let's approve this bill and allow more children that need adoptive homes and aren't getting it to avail themselves of that and move on.
Okay, let me take one speaker, and if there's anybody in the virtual world who wishes to speak, either in favor or in opposition, please sign up now. Clerk will give you 5 minutes to sign up, and you'll have a brief amount of time. Mrs. LaRue from Virginia Poverty Law Center.
Yes, thank you, Madam Chair. Valerie LaRue from Virginia Poverty Law Center. We're in support of this bill. It would allow many more relatives who currently are barred from becoming foster parents to become foster parents. I think the federal provisions are sufficiently safe. I think Senator Morrissey's comments are well taken, and we would ask you to approve this bill. Thank you.
Anybody in opposition before us? Anybody in the virtual world lined up?
Madam Chair, we do have one person. Allison Gilbreth, would you please unmute and begin your testimony?
Yes.
Good morning, Madam Chair, members of the committee. Allison Gilbreth with Voices for Virginia's Children. We strongly support this bill for the comments that Valerie just mentioned, and just reminding the committee that there's a waiver process. So there will still be the Department of Social Services involved for each case for children. This will exponentially support kinship placements in Virginia, and all 32 members of the Foster Care Coalition are also in support of this bill. Thank you.
Thank you. Okay, Senator Morrissey, did you make a motion?
I've got a quick question.
Oh, there's a quick question. Senator Hanger.
Thank you, Madam Chair. Senator Mason, the chair had previously referenced Senator Edwards' bill, which I think went through referred to finance. It's actually on the floor now for final passage.
Yes,
but how does this interrelate with that? How does this interact with that?
Madam Chair, Senator Hanger, we pulled the foster care section out, but then Mr. May just adapted it to federal law solely. So there may be a differential with the way it's done with Senator Edwards, but I don't think so. We ask for the matching portions of the bill, but we just try to make it as simple as possible. And Mr. May, I believe, has maybe another clarification that'll help Senator
Okay,
McDougal
still goes
out
through
as
the
well.
review process.
Yeah, yes, sir.
So since the
Yes,
Senate
sir.
Finance Subcommittee liked Senator Edwards' bill, you'll love this.
But even if you didn't, you may love this, Madam
And even
Chair.
if you didn't. Any further comments before I entertain a motion? Mr. May.
Madam Chair, yeah, just to look into the assault and battery a little bit more. So 18.2-57 as your standard assault and battery. Just to walk through the elements of that. So subsections A, D, and E are class 1 misdemeanors, so those would be excluded and not be a barrier crime. B would not be excluded because it's a violent felony. A and B based on a protected class. And then subsection C is only included after 5 years from the conviction date. So that's been interpreted as involving violence, even though it's not considered a violent crime.
Madam Chairman.
Okay. Yes, Senator McDougal.
Senator Servell just pulled up some of the,
Let's have one conversation, gentlemen.
some of the regulations and said that a spousal abuse, not domestic assault, but spousal abuse would be a barrier. But this says excluding assault and battery. So I'm still have some concerns about malicious wounding, unlawful wounding, and even those items under regular assault if it's not spousal abuse. So I'm gonna probably abstain at this point till we can get some clarity on those acts, those particular types.
Okay, motion has been made by Senator Morrissey to approve the bill. And is there a second?
Second.
Second by, okay, Senator Locke. Will the clerk please open the roll?
Ayes 12, noes 1, 2 abstentions.
Thank you, Madam Chair, members of committee.
Your bill reports and will go to finance.
Thank
No,
you,
it will not. It will go right to the floor. I'm so excited. So excited. Okay, I do see Senator Donovan with us, and since we just finished the cannabis, before we have time to forget what we learned, we're going to call Senator Donovan before us.
Thank you.
Senator Donovan, what bill would you like to discuss?
621, Madam Chairman.
Thank you. Before I give you the floor, I'm going to ask the subcommittee to give us a brief report.
Thank you, Madam Chair. The policy position that Senator Donovan proposed before the commission was a pharmacy vertical integration early access starting in July 1 of this year with very similar provisions to Senator Evans, but the principle was the start date as well as limiting it to the medical manufacturers is the quickest summation based on all of our previous testimony and knowledge of the subject, Madam Chair. The policy choice of the subcommittee was to move forward with a January 1 date to allow for some of the transition and appropriate safety provisions. As you might recall, we had considerable debate last year. It was the policy position of the subcommittee that we did want additional ramp-up time in terms of the public safety campaign to ensure that that was in place prior to the retail implementation on January 1 as opposed to the July. But those are part of the considerations. And I know Senator Donovan did a considerable amount of work to try to piece together what a transition process and period would look like, Madam Chair.
Thank you, Senator McPike. Senator Donovan, do you want to say anything additional to?
Thank you, Madam Chairman. Yes, this is a very narrowly drawn bill that is complementary to the other bills you've heard today. It simply seeks to have a start date of dispensable legal marijuana in Virginia sooner than January 1, 23. In order to make that happen, the regs it would stay within the pharmaceutical processors that we already have, very similar to Senator Evans' bill. The regs would be promulgated by the Department of Pharmacy because the Cannabis Authority would not yet necessarily have their regs in place, as the deadline is 1/23 for that. And so I think that this is complementary. It can go along with his. It can continue in the conversation, because the sooner we get to the process of being able to purchase legal marijuana, adult regulated marijuana in Virginia, the sooner we can protect our children, the sooner we can have patients who are consuming this have an identifiable consumable. I have an enormous number of pregnant patients that use marijuana. It may surprise you, but it is, they are not able to obtain that. There are a lot of obstacles to getting the medical marijuana. And so if they were able to access legal marijuana in a way, or adult regulated marijuana, where they knew what they were purchasing and consuming, it would be much safer and much less expensive than going through the medical route or buying it illegally. So I really think this is something that, I think things moved faster last year than we expected, and we've left this discordance between possession and purchasing, and that it's a big safety issue. And if we can find a way to do this this would give more advance money for investment in the ultimate bill when it materializes. So this literally does nothing but allow locations that have already been approved by the localities to exist and to be there, that already have safe mechanisms in place. We've been working very closely with the Board of Pharmacy to make this work for them. And I will say, when the Cannabis Authority, who has representation from the Board of Pharmacy appropriately, writes these regs for how this is done, the Board of Pharmacy is going to be very influential in that. So them modeling regs before that is in no way an obstruction. And that's why this is so narrow, because all I really want to direct in this bill is that we start a little early. And I think that's the best thing to do for Virginia, and I think our processors are a great place for us to do that. I hope the conversation can continue by you passing this bill.
Senator McPike?
Thank you, Madam Chair. Just as a follow-up, so the position of the committee at this point is we've already adopted and passed Senator Evans' transition bill, Senate Bill 313, which would put the dates in conflict with what you're proposing. One of the questions we did have is whether or not you wanted to be a part of that bill at all. And the indication at the time was you did not. And so I just wanted to confirm that you want to continue with that vehicle moving forward, but not necessarily roll yours in. Is that correct?
Madam Chairman and Senator McPike, as you all heard, there are a multitude of points that are made in Senator Evans' bill, and it is going to be debated and looked at in comparison to what comes out of the House. And I don't want this concept to get gobbled up and lost in that. And I think because this in no way really disrupts Senator Evans' bill, I'm hoping we can move this forward, because as this conversation unfolds after crossover, having a bill that speaks to this one issue instead of rolling it in and having a conversation, I think it gives us more opportunities to talk about what we can do. I hope you'll pass this bill as it is.
Madam
Senator
Chair.
Senator McPike, and then Senator Morrissey.
So thank you, Madam Chair. And just to, I guess, put a finer point in, certainly as the policy deliberations continues through the Senate chamber as well as the House, I'm sure there'll be further discussions. But at this point, your bill would be in conflict with the bill that we did pass on the transition at this point from committee. So I'd recommend that we do PBI gently, but with the same understanding that you've done a lot of work to do this transition bill and done a good job presenting the issues that they're for.
Madam Chairman.
I'll hold off on that motion until there's other questions.
Senator Donovan, and then I guess you have
it's the only conflict is that bill says regs will be promulgated by January 1, and who will write them. So it's not actually in conflict, it's in addition to Senator Evans' bill, because it gives a different date and a different process, but all of the aspects of Senator Evans' bill can proceed as well, even if this is passed.
Madam Chair.
Senator McPike.
I'm sorry, just to clarify, those are two very different policy propositions.
Mhm.
And the subcommittee endorsed a January 1 and not the concept one-year bill, which is July 1, for very specific reasons. And so I wanted to make sure that's clear. Those two are in fact conflict, with all due respect. And so I just want to make sure that that was very clear to the committee. Those are two very different policy positions. So
Madam
thank you,
Chairman.
Madam Chair.
One more comment, go ahead.
Thank you. I'll just say, as I understand it, I'm here today to speak to the full committee because decisions are not final from sub. I didn't get a full opportunity to speak in sub and, argue the points, but my point is that the committee feels compelled to pick a singular perspective, and I think that in this body, we put forward a lot of things that are parallel and similar. And I think this is one that begets a really valuable conversation for children and patients in Virginia. So I hope it'll be the desire of the committee to do something different than the subcommittee recommended.
Well, it certainly is the committee's prerogative.
It is.
I don't know if you have speakers lined up, but I will allow 45 seconds for each person who is speaking in favor and each person who's speaking in opposition. My intent is that we not hear more than 5 minutes on either side.
They can keep it brief.
Oh, I apologize. Before I take speakers, Senator Morrissey.
Thank you. For Senator Donovan. Senator, I always appreciate your comments, not only from the perspective as a legislator, but also a physician. My question is this: is there you said that it's not inconsistent with Senator Evans' bill. Senator McPike brought up the January 1 versus July 1. Other than that date, is there anything else that's inconsistent is my first question, and then I'll have one other short question.
Madam Chairman, I will let some of the subject matter experts comment on that if you want, but the two conceptual differences are start date, who writes the regs. Those are the two differences.
And Senator Donovan, under your bill, is it the Board of Pharmacy? And under Senator Evans' bill, is it the Cannabis
Authority. Which is
Okay.
on which there's representation from the Board of Pharmacy who will probably weigh in heavily on those regs because
Sure.
it's a pharmaceutical product.
I mean, but those are 2 points that really would be in conflict with each other, because who writes the regs is not something you can just,
And I'll just point
massage.
out that mine also has a sunset clause that as soon as the Cannabis Authority regs are in place, mine goes away.
Senator Morrissey, follow-up question.
Yes, at the appropriate time, Madam Chair, I'm hoping that you will address the following singular issue. If we approve Senator Donovan's bill, does that do any damage whatsoever to Senator Evans' bill, or can these two bills be resolved at a later date?
I would
when
like
it's appropriate,
I
if you
would
could.
like Mr. May to respond.
Madam Chair, Senator Morrissey. Okay, so they're not necessarily in conflict, but so much as they differ in certain respects. There is a way, if it, at the pleasure of the committee, to reconcile the differences in the language with deference being given to Senator Evans' bill at the request of the committee. For instance, the date under Senator Donovan's version, it would start this July under the Board of Pharmacy. But as soon as the Cannabis Control Authority could get the Board of Pharmacy regs moved over to them, whenever that may be, it would move over to Cannabis Control Authority. It could be before January 1, 2023. It could be a little bit after if they weren't quite ready. It just says whenever they're ready, it's going to shift there. It just starts with the Board of Pharmacy. Another example would be there's no provision for a local tax in Senator Donovan's version. She imposes a $1 million fee versus a $6 million fee. So they're not necessarily in conflict so much as we would have to iron out the details to make sure that there's, all of the information therein lines up.
Madam Chairman, we are still working with Florida Pharmacy and others, and are happy to work to align any of that language.
Yeah, I mean, that would have been helpful before the committee came. To the degree you can agree conceptually to align with Senator Ebbins' bill, that would be helpful. And
Absolutely, Madam Chairman, and that's inherent in the intent of this sunsetting. When his bill comes into action, this bill sunsets. So this is a a prequel, if you would.
I mean, the easiest way would be if we could roll your bill into Senator Ebbins' bill and make a few tweaks. But let me ask Senator McPike. Senator McPike.
Madam Chair, so there are enough complexities that we already are working through between Senator Hanger's bill, between the transition bill we've already approved with Senator Ebbin, and then the main legalization regulatory framework bill. Having another vehicle out there and tracking it is not a desirable condition based on the hundreds of pages of legislation that we're already considering. With the ability to certainly adopt different concepts that Senator Donovan has proposed into Senator Ebbins' bill, we can work that through the process and make sure and have the policy discussions of what those transitions look like. But I would highly recommend that a new separate vehicle not be moved forward through the committee and through the process. Full respect to what Senator Donovan is doing. I think there's some strong concepts. We can pick those up through the process and find
Yes,
some others.
I just want you to know we're not concluding the conversation with this committee meeting, and I am very sympathetic towards the comments that Senator McPike just made. Why don't you make one more comment, then I'm going to take speakers.
So, Madam Chairman, my opposition to that path is that my understanding of the process when it came out of committee is that mine was rolling in and maybe would talk about an early start, July 1, maybe would talk. I don't think that entertains the issue that I am trying to represent here. I am not opposed to ultimately us having a vehicle in his bill that says July 1 to whenever with the pharmacy promulgating. I don't object to that. I just need to have that concretely in that bill and not be, we'll talk about the date and we'll see what part of yours is. Because when a bill rolls in, you lose the substance of your bill.
I
And
understand.
if the substance of my bill and the integrity of that will be maintained as a prequel to what Senator Ebbin has proposed, I'm not opposed to that, but I would need to have that in place, or I feel like we need to hold them apart until we can reach the point where they can be aligned.
This committee can give direction. So if your bill's rolled into Senator Ebbins, we can provide some direction. Yes, sir, you've got 45 seconds.
Good morning, Madam
Good
Chair,
morning.
members of the subcommittee. I'm very respectful of the point Senator McPike is making about procedurally advancing a single vehicle in the transition element. To amplify and echo Dr. Donovan's points regarding the bill not being in conflict with the July 1 date. That July 1 date is important for the same policy reason the Committee 8-7 advanced Senator Ebbins' bill, which is to protect public safety. But the key point for July 1 is that the Board of Pharmacy exists, has regulations, is presently regulating these licensed processors, regulating these same products. Board of Pharmacy is ready to go. CCA, the Cannabis Control Authority, presently has 2 employees. They're a very long way from regulating these
Your time has ended, but thank you for your comment.
And Madam Chair, I would just like to introduce the next speaker. Sarah Payne is principal with Jushi, the pharmaceutical processor in Northern Virginia. Thank you.
Very good. You've got 45 seconds, and welcome, Sarah.
Thank you very much, Madam Chair, and to the committee. I'd like. Oh, let me take off my. Thank you very much, Madam Chair, and to the committee for your consideration. I'd like to thank Senator Donovan for her very hard work on this bill. It addresses a critical public health and safety issue. We do believe that the date is important here, primarily because it's a difficult task to stand up an agency, and I think there is some concern that the CCA will not be fully up and running as of January 1st of 2023. And in the interest of having a legal alternative to illegal sales in Virginia, this option would give that alternative to folks who would like to make the transition out of the illicit market.
Thank you for your
Thank
comments.
you so much.
Your time has ended. Thank you. Jen Pendadini?
Thank you, Madam Chair and members of the committee. Normal's position is preferential to Senator Donovan's bill, and it is the consumer's bill. This conversation has largely focused when it comes to legalization on who gets to make money first or next on consumers. This bill is in their interest and enacts regulated sales through operators that are already serving them in a medical capacity. Thank you.
Thank you. Yes, sir?
Good morning.
Welcome.
How you doing? I'm a small hemp dealer in Richmond, Virginia, born in Richmond, Virginia, business established here. And right now, if this bill, I'm in favor for it, the early sales, but I just ask that you address persons like myself who has been here established, spent a lot of money to get into the field, and it sounds like the pharmaceutical companies that's not from here are going to gain, and it sounds like another year from now, we might have an opportunity, and that turns our people to the consumers. That's it. And it's going to give them that much a head start. We're still not guaranteed that we will have an opportunity. So I just wanted to ask that you listen to that and understand that all industrial hemp sales is not outdoors. They are indoors as well as ourselves.
We understand.
Right. Thank you.
Thank you so much for joining us. Yes, sir.
Good morning, committee. My name is Anthony Mijares. I'm a veteran. I am the owner of Old Manchester Hemp Company. We operate here in the heart of Richmond. We are vertically set up. We process, we grow, and we retail at the same location. I am for this bill because I am in the heart of Richmond and I see the illicit market running rampant every weekend. Here I'm trying to do right, and I see this whole black market really taking the market cap now. And we are losing out on money and helping people that need to be helped, like myself as a veteran, where cannabis and hemp helped me. So we're losing out by wasting time. So I ask that you really listen to this bill, and like I said, I'm for it. Thank you.
Thank you so much. Clerk, is there anybody in the virtual world who wishes to speak?
For those attendees in the Zoom room who would like to speak in support or opposition to the bill, please raise your hand electronically now. Madam Chair, there are no hands raised at this time.
Thank you. Okay, colleagues, we have heard this bill, and we've heard the comparison between Senator Donovan's bill and Senator Edmonds' bill, which was 313.
So, Madam Chair?
Yes, Senator McPike.
I want to make sure that part of the subcommittee testimony that we also took was from those that oppose some of the early access due to the provisions that social equity applicants and the ability to actually gain a market. As soon as you stand up a market, the time and distance between the regs being published and the rest of it was of a great concern to a lot of the subcommittees. And so we did incorporate that into our consideration of why a little bit more distance that also allowed regs to catch up and other small businesses to start to prepare to submit applications for licensure under the permanent structure. And so that actually 6-month ramp-up time was one of the more important considerations to a lot of the social equity advocates that provided testimony to our subcommittee and did influence the direction of the bill. And with that, I just respectfully move to PBI, Senator Donovan's bill, with consideration that there's still policy considerations that will move forward.
Second.
Okay,
Madam Chairman,
Senator Donovan?
I hope that Senator McPike realizes that there is social equity incubation and investment in my bill. And so this gives startup money. This bill, again, is not here to disrupt any of the policy issues that we're talking about. This is about getting legal access sooner. That is why it is so narrowly drawn and why I have excluded it from the other conversations, because there's only one thing we're talking about here.
Madam Chair, 30 seconds.
We do understand.
Yep.
Senator Morrissey.
Senator Donovan has made some very important and salient points today. One of the things that you're concerned about is that the promise that it will be considered down the road won't come to fruition. I want to assure you that there's a process on the Senate floor called amendments. I promise you, your voice has been heard. all right? So whether we PBI it or we pass it and it's defeated, you are going to have an opportunity, I'm promising you, to have those specifics addressed in a bill, even if it means done through an amendment. And the last time I checked, the Senate was rather closely divided.
Madam Chairman.
This will be your final comment, Senator Donovan.
Understood. And thank you, Senator, I appreciate it. I'm just curious how we got to PBI instead of rolling it in.
The preference,
Well, I said that I was okay with that as long as there were some guarantees, and the committee a minute ago said to me, we have the ability to have some influence on how that's language. So I think I was very receptive to the idea. I said, I don't know if it's now or later, but I want to make sure that date is in there.
why don't we, colleagues, why don't we make a motion to roll Senator Donovan's bill into Senator Evans' 313 bill with direction that as much collaboration as possible be done so that your points can be in some way addressed in Senator Evans' bill. I feel very strongly that one vehicle going forward would be a benefit to the conversation, but the conversation needs to continue. If you would accept a motion to roll your, okay, I will move then that Senator.
So, Madam Chair,
Go ahead,
so
Senator
now we would
White.
have to reconsider the vote in which we adopted Senate Bill 313 in order to undo this.
We did vote on,
So-
is that correct, Mr. May?
If that's, I'll be happy to make that motion in
sure, yeah.
consideration and move to reconsider the motion which we adopted, Senate Bill 313, and re-referred to Finance, be reconsidered for the committee.
Thank you, Senator McPike. All right,
Madam Chairman,
yes?
that bill was already reconsidered once. It can't be reconsidered a second time unless it's unanimous, correct?
That's true. So, colleagues, we will need your unanimous consent
Madam
for the
Chair.
reconsideration
Madam Chair.
of Senate Bill 313. Senator Spruill.
I know I'm hard, but I know with the motion made, but there was some discussion and we never voted on it, on the PBI. It was a motion made by PBI, that was a second. We got the discussion, but we never voted
I'm
on
going to
it.
ask Senator McPike if he actually made the motion, if he did, to withdraw it.
It was made in second. I'll withdraw the PBI because that would be the predominant motion. But I will withdraw the motion to PBI.
I would appreciate that. Thank you. Okay, so now the motion before us is a reconsideration of Senator Evans' 313 bill. Was pointed out, this would be the second reconsideration, so unanimous consent would be needed. Is that correct, Mr. May? Is that correct? It is correct. Okay. All right. Motion is before us to reconsider Senate Bill 313. I believe that's a vote on the board.
Yes.
Okay, colleagues, indicate your preference.
Ayes 15, no zero.
Thank you. A motion to reconsider Senate Bill 313 now is before us. Senator McPike?
Madam Chair, I move that Senate Bill 621 be incorporated into Senate Bill 313 and Senator Donovan be listed as co-chief patron.
Very good. A motion is before us and seconded, and it still has to go to finance according to my notes. Okay, colleagues, I'm going to ask you to vote. Will the clerk please open the roll?
Ayes 8, no 7.
Now, Madam,
You'll be listed as a chief co-patron. You're now,
Thank you, Madam Chairman,
Okay.
members of the
and
committee.
it's on its way to finance.
no, it's not. Madam Chair, now I move that Senate Bill 313 be reported and re-referred to Finance.
That was to incorporate.
Madam Chairman, I think we understood that as the motion to report, so we're all.
We're all set. I think-
Well, I understand. So what I'm trying to say, we wouldn't have voted against that, is what we were trying to say.
What are you guys doing? I will ask the clerk, do you have an understanding of the motion we just did?
The motion was to incorporate that bill into Senate Bill 313, and now I believe there's a motion to report and re-refer Senate Bill 313
Madam Chairman.
with substitute to finance.
Madam Chairman, we can just ask the clerk to change our votes instead of reconsidering on that, but I think we were all in favor of the incorporation.
We were all in favor of the incorporation. Okay, does that work for you,
So
Hobie?
they want to be a yes on the rolling in.
I have Senate Bill 621 as incorporated into 313-15-0.
Thank you, Madam Chairman.
Okay.
Thanks,
Okay.
team, thank you.
Now, Senator
Yeah,
McPike.
no,
Yep,
and then
so,
thanks, team.
Gentlemen, Senator McPike.
Madam Chair, now that we're in the proper position with the outstanding 15-0 vote to incorporate, I move that the bill be reported and re-referred to finance.
There's a second. Okay. Colleagues, let's vote on this. Clerk, please open the roll.
No. Thanks, team.
Ayes 8, no 7.
Senator Donovan, your bill has been incorporated with Senator Evans,
Thank you.
and the incorporated bill is on its way to finance.
Thank you very much.
Thank you, colleagues. Senator DeSteffe, would you like to present your bill? We are finished with our cannabis bills, and I thank the subcommittee.
Madam Chair, members of the committee, good morning. I'm
Good
going to try to
morning.
make this really simple and really easy and not complex, and this is just a very easy one. And what this says is that in a jail, or correction, if a jail, in a jail, if somebody takes the camera and messes with it and it can no longer record, then that tampering of this is a Class 1 misdemeanor. If they tamper with it and there's a felony that happens, then it's a Class 6 felony. Now, let me explain real quick the catalyst behind this. 'Cause I know this is.
Mr. Chairman, may I ask my question before, so I can understand?
Senator Spruill.
I'm trying to understand. Now, are you talking about an inmate, or are you talking about someone else other than an inmate? I don't know who can mess with the camera, that's why I asked.
Madam Chair, Senator Spruill, the inmate.
Okay.
So let me walk through what's happened. So one of the inmates in Virginia Beach Jail took a wad of toilet paper, wet it, and threw it up against the camera so it blocked what happened. And they knew a correctional officer was coming into the unit. When the correctional officer went in, they beat him very, very bad with a cane. I met the correctional officer. I had lunch with the correctional officer afterwards. And that's just one instance. Well, the way the law was set out, because that individual was not involved in the beating of the officer, all he did was took a wad of toilet paper and threw it up against the camera so it could not record, or in another instance, he held something up against the camera so it could not record while an illegal act was going on, then they could not charge that individual with a crime because all he was doing was obstructing a camera.
Madam Chair.
So I know we have speakers on this. We have our sheriff, we have former attorney generals, we have a bunch of people to speak on this, but I'm happy to go into it, but that's pretty much what happened and why it's structured
We don't
as
need a
simple as this.
lot of speakers. I'm going to limit them to
Okay.
3 minutes on each side total. 3 minutes pro, 3 minutes con. Senator Morrissey.
Thank you. Senator, agree with the spirit of your legislation, full stop. Have you considered the fact, though, that you can be charged with an accessory before the fact to a felony by doing just what you described in your example, and that is an accessory before the fact is a felony, an accessory after the fact is a misdemeanor. So I'm just asking respectfully, isn't what you're trying to correct in Senate Bill 700 already on the books with the existing legislation?
Madam Chair, I'd like to, Senator Morrissey, I'd like to, if possible, defer to either Tim Oaksman or Sheriff Ken Stolley, who helped me with this and can truly answer the question the way you want with existing law. I believe the answer is that the answer may be no, but if we could pull one of those on, I'd like to, as we put it, phone a friend.
Madam Chair, Tim Oxman is online on the Zoom.
Okay, go ahead. You're our expert witness. Mr. Morrissey, did you want to repeat your? Okay. So we're waiting for an answer?
Tim Oxman, would you please unmute? Madam Chair, he is on the Zoom. He is not unmuting at this time.
And Madam Chair, I know we've had a problem with the Zoom in and out because we had at one point 6 people on this and they've lost it and they're texting me and our IT's been back and forth.
Why don't we take your speakers?
Let's do that and we'll see if we can get them to answer
we may get an answer.
Madam Chair.
Madam Chair.
Senator Boyce-Coe.
I understand that there's also a House version of this, and I was wondering if Mr. May might be able to give us a description of the differences between the two, because I understand that this was just heard and in the House side.
This morning
Am I
or
not
last night.
correct?
I'm not sure. I think they were
HB
the same, but I'm not
1332,
sure.
I believe it is.
Originally, they were the same. They may have amended it. If they did, I've not actually looked it up.
And Mr. May.
Madam Chair, just bear with me one moment. I'm going to pull it up. I think they were initially aligned, but just want to see if the other bill was changed.
Why don't you take a few minutes to look into that, and we'll
Madam
hear
Chair.
from your speakers.
Madam
Senator
Chair.
Spruill, and then we've got to get to speakers.
Thank you. I want to support your bill, but I help you understand. So you were saying that if someone who an inmate taken throw something and move the camera, and let me finish first, and no one gets hurt, then you want it to be a class 1.
No, sir. That would be a, yes, I'm sorry. Madam Chair, Senator Spruill, that would be a Class 1 misdemeanor for tampering with the recording
I
devices.
got that part. Now, if that same person do the exact same thing, and an officer get hurt, not by him because he is there, but someone else, but others hurt the officer because of what he has done, then you want the person who threw it be a class 6.
Felony. That's correct. Madam Chair, Senator Spruill, that's absolutely correct.
Thank you so much, sir.
Okay, let's hear from your speakers. Those speaking in favor of the bill, you've got 45 seconds, each person. Those speaking in opposition to the bill.
Madam Chair, we do have 3 speakers online, and Ken Stoll, which Senator DeStev has asked, is also online as well now.
Very good. Okay, so we've got 3 speakers in support online. Go ahead, 45 seconds each. We have a heavy docket.
John Jones, would you please unmute and begin your testimony?
Good afternoon, Madam Chairman, members of the committee, and thank you for taking me on this bill, and thank Senator DeSteff for introducing it. This bill is supported by the Virginia Sheriff's Association. Senator DeSteff has described it accurately. There have been situations where inmates cover the camera, and we think that ought to be a separate crime. We hope you'll support the bill, and thank you very much.
Thank you, Mr. Jones, and you're with the Sheriff's Association. Would the clerk please call the next speaker?
Tim Oaksman, would you please unmute? Sheriff Stolley, would you please unmute?
I'm unmuted. Can you hear me?
Yes, sir.
Yes, Mr. Stolley.
All right, well, thank you, Madam Chairman, for this opportunity to speak. I'll be very brief. To answer Senator Morrissey's question, Senator, I think that you're right. I think that you could be charged as an accessory before the fact. The elements of proof are a little bit different there, but you can be charged with it. I don't think you can be charged with accessory before the fact for a misdemeanor, though. And so I think that, if they intentionally move the cameras, it's just a misdemeanor. If it's if they do it with the intent to obscure a felony or assault or something like that, a drug deal or something like that, then it would be a felony. But I think, as John Jones indicated, some of what we do in corrections is to try and get people to understand what the rules are, and sometimes they have to spell it out very clearly. And so even though it's a possibility of being charged as an accessory before the fact, I think that if the prisoners know that there's a specific statute that addresses this issue, then it's hard for them to address it, and it's hard for them to get around it, and it makes it easier for us to enforce. And so I'll be happy to respond to any questions that you have.
Thank you, Mr. Stolley. We appreciate the work you're doing in Virginia Beach.
All right, thank you.
Does that conclude your presentation?
I believe, Madam Chair, we have one more speaker there.
Oh, we have one more speaker.
Christina Mapes, would you please unmute?
Christina, you have 45 seconds. Thank you for joining us.
Good morning, Madam Chair. I'm a captain with Virginia Beach Sheriff's Office, so you heard from my sheriff, Ken Stolley. But one of the problems that we face with inmates covering the cameras, it frustrates our ability to investigate criminal activity inside the facility. And this protects inmate victims as well as staff victims as well. And we're talking about physical assault, sexual assault, as well as tampering with security devices. Thank you.
Thank you.
Madam Chair.
Okay, the bill is before us.
Madam Chair.
Senator Morrissey.
Quick question to the last speaker. I don't think in subsection B, it says any person, and then you do a carve out for law enforcement officer who covers the thing can be charged with a misdemeanor. I don't think you want to do that. I think you want to delete everything after any person on line 16 down to justice, the end of the word justice on line 18, and say anybody who covers this is guilty of a misdemeanor. Otherwise, you're saying if a law enforcement officer or jailer does it, it's okay. So that's my motion, a floor amendment to delete that language.
Madam Chair, before we move on to that, I have the language up from the House, and it is in the same spirit. It actually says, and I would move this as an amendment, that in subsection B, any person who intentionally covers, removes, damages, renders impairable, or otherwise obscures a security camera without the permission of the sheriff, jail superintendent, warden, or director of corrections or Department of Juvenile Justice is guilty of a Class 1. That way, it doesn't hurt the, actually, it's a little.
I think that corresponds with Senator Morrissey's intent.
Okay.
Would you please move that as an amendment? And do you consider this to be a friendly amendment?
I believe so. I'll check with staff, but I'm pretty sure, because I believe without was on line 20 of the PDF of mine, but if it makes it clear for the committee.
It's exactly the same thing.
Senator Boysko, did you move that amendment? Is there a second?
Second.
Second. Okay, all those in favor of this amendment signify.
Hold on. Yeah, I'd like to get counsel to chime in if
Okay.
that's okay, Madam Chair.
Hold the vote. Mr. May.
Madam Chair, yeah, everybody's on the same page here. Senator Boysko's saying the same thing as Senator Morrissey, and that would also align with the version of the House bill. I can go through the language after to make sure there's no other cleanup necessary, but this would be the amendment as I see it, what we would need. On line 16, after person, strike other, and continue striking all the way down through juvenile justice on line 18.
Got it.
So what you would have is that you're basically taking out all the exceptions of who couldn't be penalized underneath the rules. So it's just going to be any person, and then you continue with the text of the bill.
I think, thank you. Motion was made by Senator Boysko, seconded by Senator Reeves. All those in favor signify by saying aye. Aye. Okay. Mr. DeSteph, do you have any closing remarks?
Madam Chair, I think this actually makes it safer for those who are incarcerated and those who are protecting them. So with that, I'd move passage of this bill.
Colleagues, would you move the passage of the amended bill?
So
And it
moved.
has to go to finance.
So moved.
And there's a second, okay?
Second.
Senator Boysko made a motion, Senator Mason seconded. Please open the roll.
Madam Chair, members of the committee, thank you very much.
Ayes 15, no
Thank
zero.
you. Thank you. Okay, Senator Kiggins, Senate Bill 702.
Thank you, Madam Chair, members of the committee.
Madam Chair,
Sorry.
I think Hoyt had something to say.
I understand. Senator Obershane, do you have something
I'm
else you
sorry.
have to go to?
Oh, well, you can.
I will ask Senator Kiggins if she graciously agrees to, okay. Senator Obenshane.
Madam Chairman, thank you very much.
Move report.
No,
Thank you.
let's move to Senate Bill 680. No reporting without hearing the bill.
It's a really good one.
Some committees do that. This committee does not.
Madam Chair, members of the committee, I'll be brief. We have, over the course of the past couple of years, tinkered with eligibility for parole, whether it's geriatric parole, parole for terminally ill prisoners and others. This deals with eligibility for geriatric parole. And last year, we spent a lot of time talking about who should be and should not be eligible for terminally ill parole. And remember, that the definition of terminally ill is a bit broader than imminent death. It is, they're going to die, and there's a lot of discretion about how far out terminal illness falls. But there are inconsistencies between who's eligible for terminal illness parole and who's eligible for geriatric parole. And what this bill does is it conforms the two. So if this bill were to pass, it would prohibit parole for these folks who are currently ineligible for terminal illness parole. First and second degree murderers, felony homicide, lynching deemed murder, killing of a fetus, person suffering death from attempting to lynch another person, and armed robbery. Those are the categories that parole would be prohibited for, which is, as I said, consistent with who we prohibit parole for terminal illness. So arguably, we ought to be at least as restrictive for geriatric as we are for terminal illness. So that's what the bill does. Simple.
Thank you, Senator Obenshain. Are there questions of the committee members? Senator Morrissey and then Senator Sproul.
Senator, why would an individual who was convicted of robbery as an 18-year-old, has spent 40 years in prison, and either has a terminal illness or, strike that, is otherwise eligible for geriatric parole, why are you excluding that person from being eligible for parole, which doesn't mean they get it? I'm trying to wrap my head around that.
Madam Chair, if it would make Senator Morrissey feel more comfortable to take that out, I can live with that.
Madam Chair?
Senator Morrissey.
It would make me more comfortable, but I would like to take all of them out there.
So you're against the bill?
Okay. I want you to.
And I understand that. You and I
want to give you the opportunity to explain why, if somebody has committed an egregious offense in A through P, but has spent 30 or 40 years rehabilitating themselves, and it is unquestioned that they have done that, and they are dying, and why would we want the state to hold on to them for the last 2 years of their life instead of sending them home? And I'm not saying that in a dismissive or churlish fashion. I really want you to explain that to me.
Madam Chair, members of the committee, Senator Morrissey, you and I just have fundamentally different view about the role of parole. We definitely have expanded the eligibility of parole for both terminal illness and for geriatric. And I happen to believe that we need to conform the two, that these are special categories of crimes, felony homicide, lynching. I think that these categories of crime ought to be conformed, and if we're going to say that you're not eligible for parole, these belong on that list of things that you're not eligible for parole for. You either agree with me or disagree, and you and I have had this discussion in different committees, and I know that we have a philosophical difference about this. This isn't about the larger issue of whether we're going to have parole at all or not. This is a very small subset.
I just have a question of clarification, and then Senator Sproul. Oh, okay. I guess I can go. You go ahead, and I'll save my question.
Senator Morrison asked the first question about the armed robbery. What happened if these crimes you're talking about, and the doctor says he's on his deathbed, and he has 6 months?
This doesn't affect that. This is just geriatric. This does not touch terminal illness parole.
Thank you.
Madam Chair.
Senator Boysko.
Perhaps David might be able to clarify, but didn't we set this policy in 2020 already on conditional release?
I'm sorry?
Didn't we already make the policy in 2020 during our special session on conditional release?
It was, yeah, it was in 2021. I will ask Mr. May.
It was 2020,
You're right.
the summer.
We defined geriatric release. We had conditions. It was Senator Bell's bill. Mr. May, can you respond to that?
Madam Chair, I'm pulling it up now to find the exact date. We did in fact consider that, and we had a debate over, as I remember, Senator Morsi's disagreement with the, dispute over the Class 1 felony language, which is what you see at the top of this list that's already currently in the code. But we have not considered these crimes, which would disqualify you from parole. We didn't consider those at that time, but we did debate the policy choices generally about the conditional release.
So just a follow-up question, just for purposes of clarification. Are you trying to conform this bill to what our current geriatric release law is?
No, we're conforming the disqualifiers for geriatric to the disqualifiers for terminal illness.
Okay.
That's it.
Okay. All right. I think this bill is very clear. Do you have any speakers, Senator Obenchain?
Not unless you really want to hear
No,
them.
we don't need to hear any, but.
I can bring a couple up, but.
Okay. A motion has been made. It doesn't have to go to finance. A motion has been made to report, and there was a second. I don't know who made the motion. Senator McDougall first and Senator DeStep seconded. Colleagues.
Substitute motion.
Oh.
I'm sorry, did you want, go, I defer. Substitute motion that passed by
Senator
indefinitely.
Morsi.
Second.
Well, let's hear Senator Morsi's substitute.
To PBI.
To PBI. And there's a second. Okay, substitute motion takes precedence. And so the motion before us is to PBI the bill. All those in favor, go on the board, please. The motion to PBI.
Ayes 8, noes 7.
Thank you.
Sorry.
It's all right.
We enjoyed having you in front of us.
It's good to see everybody. See you in
I
a few
tried to be
minutes.
kind to everybody who.
Very generous.
Thank you, Madam Chair, members of the committee. I have Senate Bill 702, and this bill allows for the, we have to move the substitute, I believe, right? And if council want.
It's Bill 702.
702, that's right.
Move the substitute.
Okay, substitute has been moved and seconded. All those in favor signify by saying aye. Aye. Thank you.
Senate Bill 702 allows for the disclosure of prior criminal history of marijuana offenses when public safety is at risk. If the license, permit, or registration will prohibit marijuana consumption, the employee has to disclose prior to marijuana arrest, their prior marijuana arrest, criminal charge, or conviction. In my opinion, it's a safety issue for the employee and the community and for industries, for example, who operate heavy machinery, repair ships and aircraft, or involve significant risks to perform. This bill was brought to us by the Port of Virginia, a couple of you that work there, and I've also heard complaints from the heavy contractors that they're concerned just about hiring for people, that this might be a safety issue, just prior marijuana convictions. The bill's intent is to prevent accidents if marijuana affects the ability of their employee to do their job safely, and I know we have one person that I would like to have speak if possible.
Yes, we can take your speaker. Is there a
Madam Chair.
Senator Mason?
So criminal history, and whether I have a couple questions, but the first one is, why isn't this in judiciary and in our criminal subcommittee if we're talking about criminal history and disclosure? I think it just seems to be, I mean, we did a bunch of marijuana today, which this may even be in conflict with, but, so I see where it may have gotten lumped in with the marijuana, but this looks like a judiciary.
Well, we have done bills in this committee that have dealt with, it could go to the same sub, but we have done bills that
Madam
have
Chairman.
dealt with, not having reporting crimes.
Madam Chairman.
Let me ask Mr. May. Mr. May, is there a particular reason why this came to our committee? Were we amending a certain section of the code? Is it because it had marijuana in it?
Madam Chair, we have considered similar issues before. I would say they also get routinely referred to judiciary. I think we don't refer the bills, the clerk does, but there's, once the big marijuana thing came up, we've kind of by virtue started to hear a lot of the expungement and sealing provisions related to marijuana. So I'm guessing maybe that's the link of why this came here.
Madam Chairman.
Yeah, I'm sure there was some rationale. Senator Serville.
Well, normally the clerk refers bills based on the title of the code that it's in. 19.2 always goes to judiciary, and I suspect she saw marijuana in the title and sent it here because of that. But this treads on expungement policy is basically all it does, and it doesn't really get into any of the policy areas this committee normally gets into, like, adoption or foster care or provision of social services. This has to do with expungement.
Do you want to make a motion for?
Yeah, I move that we refer to judiciary. Madam Chairman, speaking to that motion, I also noted there's no fiscal impacts. There's no Monday deadline on this, so we could take it up next week.
There is no fiscal impact, that's correct. And I believe that can be a voice vote to refer, no, it's got to go on the board. Okay, colleagues, a motion was made to refer this bill to judiciary, and it was seconded. Please open the roll.
I tried.
Oh, sorry, sorry.
Oh, sorry. Thank you. Oh, that's good. Thank you. Sure.
She would like her bill. She would
don't,
like her
no.
bill heard.
I want it to be heard.
I was
I don't really
13,
care
those
at this
two.
point where, just somebody. Thank you.
Thank you, Senator Kiggins. Okay, Senator Morrissey, Senate Bill 673.
Good morning, Madam Chair. Good news and good news.
Good morning.
Good news is this bill does not involve cannabis, hemp, or barrier crimes. The other good news is that I'm going to be very quick. My bill, Senate Bill number 673, simply allows the governor or member of the General Assembly or agents to go into any local jail. First thing, we already have this legislation for DOC facilities. Section 53.1-30 says the governor and members of the General Assembly may go into the interior of any state correctional facility. During the off session, several people, including several of the members of the state Senate that I'm looking at now, did just that. This bill also allows them to go into the jail. And that's all it does. But many of us are already doing that. We're going into the jails. We're not meeting any opposition at all. This just codifies it.
Very straightforward bill. Colleagues, do you have any questions? Are there any? Nobody wants to comment? Very good. Motion has been made by Senator Reeves to report. Mr. May.
Oh, excuse me, there is a, thank you. Move the amendment. Thank you,
Okay,
David.
motion has been made and seconded to move the amendment. All those in favor signify by saying aye.
Aye.
Okay.
Now, move the report as amended.
What is the amendment, Mr. May? Just so we're clear, I know people are getting antsy, but this is an important, every bill is important.
Madam Chair, there would be two line amendments
Okay.
to accomplish one purpose. The first is on line 14 after assembly, comma, we would strike the and on line 14 after board, we would insert in their guest. The effect of that would be to say that the governor, members of the General Assembly, agents of the board, and their guests would be able to enter.
Okay.
Madam Chair,
Yes, Senator Sproul.
can a guest go into the state prison now? If we can go, can a guest go in with us?
Yes, that's what it covers.
Thank you.
Okay, I thought I heard a motion to report as amended.
Madam
Senator
Chair.
Cosgrove.
Madam Chair.
Senator Cosgrove and then Senator Boysko.
Thank you, Madam Chairman. Senator Morrissey, I'm looking at this and says the governor, members of the General Assembly, and agents of the board may go into the interior, but no place does it say, unless I'm just missing it, they have to be accompanied by a corrections officer or sheriff's deputy or, I mean, I just can't go in there and say, hey, let me in, right?
The normal, thank you. Senator Cosgrove, the normal process is that in almost all situations that we've been, they go through the normal process. They're sometimes tested for COVID. They go through security. They have to do anything else that any other individual does. When they're finally meeting with an inmate, they are by themselves, but there's no special entry privileges that would be given the governor or a member of the General Assembly.
Senator Boysko, did you have a question?
Thank you, Madam Chair. There was a question about whether or not you would be able to bring a guest. I just wanted that clarification because my understanding having made that request before, have been turned down a few times. So just wanted that clarification on that, at least that the policies be congruent with one another.
Mr. May?
Madam Chair, Senator Boysko, the companion code section for state facilities is going to be 53.1-30, which reads, "The governor and members of the General Assembly may go into the interior," otherwise strikes the language after that. So it's just the governor and the General Assembly members in that version.
Madam Chair.
I think we need to move this bill. Senator Cosgrove.
And I'm sorry to bring this up again, but I am really uncomfortable in thinking that I can go to the Chesapeake Jail and under the lines of this code, I don't have to be accompanied by a deputy or a corrections officer. I'm sure I would, but at the same time, it just seems like there ought to be something in there. I mean, it's not in the existing law now, but it seems logical.
Madam Chair, I'm not trying to muck it up, but Senator Morrissey is probably a pretty good scripter, or David May, something with procedure guidelines in accordance with the jail, because 99% of the time you're getting escorted. So
I'll make a suggestion if Mr. May approves. As Senator Cosgrove just said, the existing law says that the governor and member of the General Assembly can go into any state correctional facility, full stop. That's under 53.130. If you want to add in my legislation under or pursuant to normal protocol or normal procedure, I don't have any problem with that.
Mr. May, do you have some language?
Madam Chair, I would turn your attention down to lines 19 through 23, which read essentially that except for the announced and unannounced inspections, which is not what we're talking about here, these are DSC inspections, the sheriff, the jail administrator, or other person in charge of the facility shall prescribe the time and conditions under which attorneys and other persons may enter the facility. So there's going to be a process, and this directs them that they have to create a procedure for that.
Okay, so that's.
I would ask Senator Cosgrove if that assuages his concern.
Yeah.
Okay.
Okay. All right, so, and we don't have to add that.
No.
Because it's, okay, so colleagues, let's operate by motion. Do we move to, yes, Mr. May?
Madam Chair, I believe we adopted the amendments to add their guests, so
Yeah.
we would need to undo that.
Yes, we would. Thank you, and this was just a voice vote. All those in favor of withdrawing the amendment signify by saying aye. Aye. Okay, so now your bill is just as it is, and Senator Mason moves to report. Senator Boysko is a second. Senator DeStefano, one last comment.
I actually just had a question as I'm reading through this. When we talk about the governor, members of the General Assembly, and the agents of the board, but the agents of the board, and we've added guests. Is it guests of the member?
No. We struck it.
We're not doing
We
guests.
struck it.
Okay, got it. Thank you.
Motion is before us. The bill does not have to go to finance. Will the clerk please open the roll? Okay. All right, I'm the last one on the agenda.
Ayes 13, noes 1, 1 abstention.
Thank you. Senator Mason, I'm going to talk to you about Senate Bill 622.
Senate Bill 622.
We have a substitute.
Mr. Substitute's been moved and second. All in favor, say aye.
Aye.
Those no, substitute's before us.
Okay, Mr. Chairman, what this bill does is it just requires sort of a truth in advertising when we're talking about recovery homes. Recovery homes that are both certified by the Virginia Association of Recovery Services and at Oxford Home Incorporated. My substitute removes language that had a zoning ordinance carve out for these homes, so it removes that language. And what it does is it says on Part B, every recovery resident shall disclose to each prospective resident whether the resident was certified by a certain credentialing agency, or whether it was certified by the Oxford home. And then we also have language that the Oxford home has to disclose that it's self-governed and it's unstaffed. This information also has to be provided to prospective clients. And that's about it. That's really the bill. The nexus of this bill, we had an unfortunate situation in Northern Virginia where somebody in recovery actually was in this particular case, I don't want to mention the home, but was in a home, and the individual perhaps was unaware, the family was unaware that was a real self-governance model, and there wasn't staff on site, and it wasn't, didn't have a full-fledged treatment program. The Department of Behavioral Health Services licenses programs that have treatment programs. This is really a housing kind of model, and that's a distinction you should know. I may have a speaker or two, but...
Questions from the committee for Senator Favola? Are there any speakers in the audience in favor of the bill? Okay, super. Come forward to speak, sir, and then we'll have everyone stand and wave. Yes, sir, your name?
Mr. Chairperson and members of the committee, my name is Paul Stevens. I'm a person in long-term recovery from substance use disorder, and I'm with Oxford House, Inc., one of the 2 credentialing entities for recovery residences in Virginia. On behalf of Oxford House, Inc., the 1,100 members of our 158 self-governing and self-supporting Oxford houses across Virginia and their families, we strongly support SB 622. It will accomplish its expressed intended goal of increased transparency and informed consent in recovery residences and through the Department of Behavioral Health and Developmental Services. It will improve operations for both the Oxford House model and Virginia Association of Recovery Residences models, and will clarify the roles of Oxford House, Inc. and VAR as the credentialing entities for DBHDS. Oxford House would like to sincerely thank Senator Favola for her willingness to work with us to make sure this bill does the most good for all recovery residences, but more importantly, the most good for the thousands of Virginians suffering from substance use disorder who will find support, recovery, and community in a certified, well-run, safe recovery residence such as an Oxford House. Our organization, our individual homes, all our members, and all Virginians in recovery, and those yet to find it, owe her a debt of gratitude. SB 622 and its bipartisan counterpart in the House will improve the lives of Virginians, and we ask you to please vote yes.
Excellent, sir. Sir, do you speak on behalf of this group of the gentlemen? Come forward. Tell us who you're with, and we'll ask.
Okay, my name is David Rook. I'm with the Virginia Association of Recovery Residences, and also on behalf of True Recovery RVA, which operates 187 certified recovery house beds here in the metropolitan area. And I think Paul said it all from Oxford. So great. I just say that we are in support of it, and that we're happy that it's here and being heard today.
Excellent. And those in the audience in favor of the bill, please stand. Thank you very much for being here. Thank you. Anyone in opposition to the bill?
Mr. Chair, there's one person online that's like to speak in support of the bill.
Okay, Ms. Mendez, we have 10 minutes to gavel into the Senate. You have the floor, ma'am.
Thank you, Senator Mason. My name is Anna Mendez. I'm the Executive Director of Partner for Mental Health in Charlottesville. Please support SB 622. It will increase accountability and transparency as we help clients make truly informed decisions about the housing situation that is best for them. I would also like to say thank you to the Senate Operations and IT team. You guys are rock stars.
Thank you, Mrs. Mendez. Senator Hanger.
Thank you, Mr. Chairman. I just want to thank Senator Favola for taking into consideration Oxford House and others in your substitute. So I move the bill be reported as substitute.
The bill's been moved to report and seconded. Please cast your ballot accordingly. Thank you, Senator Favola.
I appreciate that.
And committee will rise.